Okay, so good afternoon. Thank you all for being here. I'm Antonino Ali, and I'm one of the organizers of this conference with Marco Pertile and Sondra Faccio. The Dean of the Faculty, my friend and colleague Fulvio Cortese, is in Rome, so he told me to greet you and to welcome you here in Trento at the Faculty of Law. At the same time, I would like also to thank the Faculty of Law and the University of Trento for their financial support, and the administrative staff, in particular Giorgia Sartori, for their work, and also the precious work, in particular of Sondra, in organizing this conference. This conference was organized despite the difficult time of the pandemic, and it is a pleasure today to see so many distinguished and let me say vaccinated colleagues here. Why here and not on Zoom or other video conference platforms? Well, one of the reasons is that the cultural exchange we have when we are in the same room, it doesn't matter if it's a nice conference room like this one or it's the table of a restaurant, is unequaled by any other video conference. But anyway, we are also streaming, and there are more or less 100 participants to this conference, which are going to follow us and follow the workshop online. So let me thank before also our colleagues, which are the editors of the Brill series in the field of international investment law, and in particular, Attila Tanzi, who is going to be with us in a couple of minutes, Tarcisio Gazzini, Eric de Brabander, who is joined us on Zoom, for their support. And this is the 8th workshop in a series started in Leiden, and then in other universities like Geneva, Lausanne, Norwich. And today we are here in Trento. And today I was talking with Tarcisio, and the idea was that actually we are very open to new suggestions. So, and events in other universities. So maybe in the near future, we may see other of these events around Europe and maybe around the world. So let me thank you now and give the floor to Sondra, who is going to tell us a little bit more about the rationale of this conference and workshop. Thank you.
So thank you, Nino, and thank you everybody for being here today. It's a real pleasure to see you here in Trento for 2 days of seminar. Well, the idea behind this seminar is somewhat self-explanatory. The pandemic has brought dramatic change on our lives, but also impacted upon economic activities. States, to face the crisis, have adopted a number of regulatory measures. Some other states have failed to adopt sometimes regulatory measures to face the crisis, and regulatory measures, in any case, strategies adopted by states will soon, maybe soon, challenged by investors before investor states tribunal. So the idea of this seminar is to discuss the challenges and the new trends brought by the pandemic in relation to international investment law and investment regulation. We will discuss these challenges and trends from 3 different angles that reflects the 3 panels we have today and tomorrow. So the first panel will explore whether and to what extent the pandemic has impacted on investment screening, as well as on the adoption of mechanisms to address risk to security or public order. The second panel will address investor states claims and discuss how arbitrators will probably assess the violation, the application treaty standards in relation to states' regulatory measures adopted in relation to the pandemic, to face the pandemic, as well as states' defenses, what could be state defenses in this regard. The last panel will address the role of scientific data and knowledge in relation to the assessments of states' regulatory measures before investment tribunals. That will relate not only to measures adopted in these times of pandemic, but also in relation, probably in relation to future environmental claims that may arise in relation to climate changes. These are our panels today and tomorrow, and I hope that will gather the interest of the public. Thank you.
So thank you very much. I think that's all. Just a few words on the structure of the workshop. We'll have 2 panels today and then 1 panel tomorrow, as mentioned. Tomorrow, there will be also a book launch, which will be entirely online. We thought it would be a good idea to present the last book of the NIOF Investment Law series, the last published book by Reza Eftekar. The book is titled The Role of the Domestic Law of the Host State in Determining the Jurisdiction, Razione, Materie of Investment Treaty Tribunals, the Partial Revival of the Localization Theory. So the book will be presented tomorrow by the author. The session will be chaired by Eric de Brabander, and the discussant will be Filippo Fontanelli of the University of Edinburgh. So stay tuned. After the last panel, we'll have the book launch. The last point, perhaps the panel are symmetrical, 15 minutes for each speaker. Then will be 20 minutes for the discussant or the discussants, and then the time for a Q&A session at the end of the panels. That is definitely all. So I would kindly invite Professor Acconci, who is the chair of the first panel, and then the speakers of the first panel to reach the podium. Thank you very much.
To this first, good afternoon and welcome everybody to this first session of this expert meeting. I would like to take a moment to thank you for attending this session. To those of you that have come here today, it's good to see you. And to those that have joined us online, I hope that the connection holds so that you can participate fully. I would take this opportunity to thank the organizers for inviting me. I am Pia Acconci, full professor of international law at the University of Teramo in Italy, and I am also the academic coordinator of the Jean Monnet module on EU investment law. I am delighted to be here. I was very happy when I received your kind invitation, as these moments are always an opportunity to share views with people with the same interest. And even if I have worked on this subject for many years, I continue to learn, especially while exchanging ideas in this environment. The aim of this first session is to understand how the COVID-19 pandemic has impacted on risk and screening mechanisms concerning security issues. We have in total 1 hour and a half. This panel will proceed along with, let's say, a traditional line. Each speaker will have 15 minutes to make a presentation. The discussant will have 20 minutes to make his comments, and then we will have the Q&A session. Of course, I will ask the panel members if they would like to make further comments or closing remarks. We have a really good panel of experts. I introduce our experts in the order that they will speak. So first, we have Professor Antonino Ali. He is an expert of screening mechanisms, particularly of the EU foreign direct investment screening mechanism since its establishment. He is an associate professor of international law at this faculty and at the School of International Studies of Trento. And before, he was assistant professor at the University of Milan and of Geneva. He teaches a course on the interaction between national security and European international law. His other fields of research are international sanctions, terrorism, and the impact of international and European law on national security. Our second speaker is Jens Hillebrand Paul. He's a course director at the Academy of European Law in Trier, Germany. He is also adjunct lecturer and doctoral fellow at the Institute of Globalization and International Regulation at Maastricht University, the Netherlands. He holds an LM from Harvard Law School, and is an English and Irish solicitor and a member of the New York Bar. Last but not least, we have online Francesco Maria Salerno, is the managing partner of the Brussels office of the law firm Gianni Origoni. He has extensive experience in European Union law, carrying his activity before the Commission and the Court of Justice of the European Union. In particular, in addition to defending companies affected by antitrust legislation, Francesco Salerno deals with cases originating from state measures such as aid, regulation in sectors with a high rate of European harmonization, and last but not least, with the Italian foreign direct investment screening mechanism that is so-called golden power. I will finally give the floor to Professor Tarcisio Gazzini from the University of Padua to make a few comments as a discussant. Professor Gazzini is a distinguished professor of international law at the University of Padua and is specialized on international investment law, particularly on the interpretation of international investment treaties and on other fields of international law, such as the use of military force, economic sanctions, and international organizations. Before coming back to the University of Padua, he was professors in several foreign universities like the University of Glasgow, the University of Amsterdam, and the University of East Anglia. I would also like to mention that Professor Gazzini is one of the protagonists of this series of seminars on contemporary perspectives on international investment law. And then I will take questions and comments for the Q&A session. Please think about your comments and questions as we move through this session. I would say that we can start with Professor Ali's presentation. Professor Ali, please, you have the floor. Thank you.
Thank you very much, Mr. Chair, or Mrs. Chair. So I'm going to talk about what happened in other ways after COVID, but to understand in the field of the screening of FDIs. And to do so, I'm going to talk a little bit about FDI screening mechanism also before COVID, because what I'm going to say is that, as we know very well, in particular, in the past decade, we have, it was very rich in terms of novelties in the field of FDI screening. The motivations or the determinants of FDI screenings were different. For many decades, the policies were focused mainly on military hardware and defense sector. So even in the 80s and the 70s, during the Cold War, we had those determinants, which were fundamental. They are still fundamental, but we can see that, let's try to imagine the phenomenon of FDIs as a river, the determinants and better the different rivers bringing water to the screening mechanism are different. So different are the motivations. Well, in the 80s and in the 90s, there was the phenomenon of privatization of infrastructure assets. And this was perceived as a possible threat, especially when, let's say, some malicious funds, maybe governed by some states, may do a takeover of those companies. But in the middle of the 2000, we had broader political responses also by several states, in particular by United States. So it means that we started to see a completely different scenario. And let's say that a very important, let's say, switch was happened with the end of the Cold War, because once the world started to be a G0 world, using the Bremer words, so a world in which it's everybody against the other. No? Yeah? We started to see very different political responses. And also, let's not forget that the high oil prices brought a different scenario, especially from an economic point of view, because we started to see the intervention of sovereign wealth funds and of state-owned enterprises. Since 2006, in particular, OECD has hosted a dialogue on international investment, and in particular on the problems of the use of security clauses. In particular, there were different roundtables yearly before OECD, or organized by OECD, in the field of monitoring and exchange information and of investment policy, in particular in the field of screening mechanism. In 2009, and this is very important, OECD agreed, and so governments agreed better, on guidelines for recipients' country investment policies relating to national security. And this is a very, very important document, which is really fundamental to understand also the development of the policy in this field. But as I said before, especially in the last 15 years, we started to see new threats and also new justifications or narratives for the introduction of Fdi screenings. In particular, after, let's say, 2007, 2008, we had, again, the intervention of the ECD trying to understand if actually we had new threats to national security that could impact also the flow of foreign direct investments. Let's not also forget that in 2007, 8, and 9, partially, we had the global financial crisis. And the global financial crisis was very important, but the answers by the states were actually not negative, but positive. In other words, we had a crisis, a financial crisis, and the reaction of the states was trying to look for investments more than dealing with stopping investments or mitigate those investments at national level. One thing which is very, very important is that before COVID, at least, what happened is that we had little convergence towards common criteria in the investment policies of the state. In other words, we had very different structural differences, scope, approaches, even the organization is completely different. There are states who are using actually a huge amount of money, investing a lot of money in screening investments, using not simply administrative staff, but even the intelligence to screen those threats. And you can understand also why, because if they are perceived as national security threat, maybe something could be said also by the intelligence agencies at national level. But what happened is also that we started to have other, let's say, determinants for the screening of FDIs. In particular, we had the digitalization of personal data, so the technological development. robotics, artificial intelligence. Let's not forget that in the last months, OECD prepared a very good report on artificial intelligence and Fdi screenings. And also on the other side, we started to have also the phenomenon of new actors, the surge of Chinese direct investments in Europe with an exponential growth. Let's not forget it. You want to have a look at the merits data on this. It's very simple to see that, I mean, before 2005, actually, China was not an investor almost at all. And the growth was, as I said, exponential. And in 2017-18, we had the top of those investments, and then a huge drop in Chinese investments worldwide, and in particular in the United States and in Europe. So on the other side, as we know very well, especially since we had the Trump administration, we had a growing rivalry between China and the United States. And things, let me say, it doesn't seem that are really changing also with the Biden administration. After 2016, so more countries adopted new policies and also made significant adjustments to existing mechanisms. So when we analyze the phenomenon of Fdi screenings, we have to analyze the introduction of new mechanisms, but also the amendment, the modification, or something that was very, let's say, brute or simple actually in the past. And now it's getting more and more sophisticated. And that's why also, as I said, in March 2018, OECD started this kind of short workshop dealing with investment policies and the new threats and the new reaction, the new policies of the government. What is very important is that also we read that there was an evolution even in the rationale or in the narratives used by states around the world dealing with national security, and in particular the perception of which assets shall not be in the certain hands. This is very clear in many documents of OECD. Now, let's have a look at the pandemic of COVID-19. I did a research, of course, I mean, I've been helped by these, some reports, very interesting reports by OECD and also by the European Commission, but mainly by OECD. And between, let's say, September 2019, even before COVID, and March 2021, we had something like, let me move here, we had 39 of the 62 states invited to participate to the Freedom of Investments Roundtable, which modified their investment policies in a way or the other. And a big part of this number was made after March 2021. So, sorry, 2020. And there was, and this is very important, a shift in many countries, also in what is needed to safeguard national security. But let me say, and this is a topic that I think needs more analysis and more researchers, is even the notion of national security, which is a concept that, according to OECD, even in the 80s, is a very strong political concept, but should be adopted. And seriously, in the last 20 years, at least, we have seen a broadening of the concept, and this is very important, especially in the field of economic security, energy security, and also cybersecurity. All those components, let's say, let me tell you, they were already present in a way or the other, even in the past, but now they are, let's say, taking more and more space in the concept of national security. So what happened really is that the pandemic has led to a certain acceleration of a movement that was already present. So the determinants were different, but at some point we had a boost because of COVID-19. And you can see here, it's a quite interesting picture we have here. In this figure, we see that the evolution between 1990 and then mid-March 2021, and you can see what kind of huge boost we had already before COVID-19. And in yellow and light yellow, you can see new mechanisms associated with COVID and also reforms associated with COVID. So amendments to previous FDI screening mechanism. And this is very important. So this big picture also tell us what kind of impulse COVID give to FDI screening. The COVID pandemic also, as you can see here, and this is, let's say, we are getting more into details because it's between 2018 and actually March 2021. The source is always OECD. We can see that we had a huge boost in the, let's say, March and between March and January 2021. In particular, but let me say that, and this is very, very interesting. A little before that, 1 year after COVID-19, the pandemic was declared by WHO, we stopped to have intervention of states in the field of, let's say, modifications of the FDI screening mechanism because of COVID. But actually, we started to have broader modifications of the screening mechanism, not only because of COVID, but for a more, let's say, general effect. That is the international cooperation in the field of FDA screening. So let me say that still there is little convergence, but in a very light way, we're starting to see a phenomenon which is there a little convergence, but there is a convergence between the different legal systems in the screening mechanism. So we are, let's say, we are moving from no convergence at all to so divergence actually to a little convergence. And let me now use the example of, and I have just 3 minutes, if I may, of the European Union. We know that after 2017, and actually in particular in Germany after 2016, we had an acceleration in the field of screening mechanism because some companies dealing with robotics and other advanced fields were bought by Chinese companies. Let's not forget, although 16, 18 is the top of the intervention of Chinese investments in Europe in particular. Well, after that, we started to have a political intervention, and this political intervention, as we know very well, brought to the adoption of regulation to 2019 452, and this is a regulation dealing with establishing a general framework in the field of foreign direct investment screening mechanism. I'm going very fast because, I mean, the time is running. What is very clear, and we should not forget, is in this case, the boost over the introduction of foreign direct investment mechanism was not anymore, let's say, some political inputs nationally, but the same European Commission started to require that foreign investors should be controlled. This phenomenon was already there before COVID. In March 2020, the European Commission was very, very clear, and this concept was again reinstated by the European Commission just a few months ago. States should adopt screening mechanism. I'm going to be fast in this and close. Let's not forget that at the moment we have more detailed rules, a certain kind of convergence, and also the intervention of the European Union, which in some ways is also boosting the intervention of the different states. Before the regulation of 452, we had, before this regulation, we had less than half of the member states of the European Union with the screening mechanism. Now we have 24 out of 27 member states. And let's not forget that, I mean, UK is not anymore a member of the European Union, but they are going to introduce on January a new national security and foreign investment screening regulation, so a statute actually. And so it is actually a phenomenon that we are going to see for some decades. It's not just something that we are going to see attached or linked to COVID and to the pandemic. I'm really sorry because my time is out, so I'm leaving everything and the other, let's say, thoughts and analysis to the written document that we are going to prepare in case we are going to publish our works. Thank you very much. Thank you.
Thank you. And of course, you can make further comments before closing this session. So I would like to make a few comments, but I don't take time, and I give the floor immediately to Jens Paul, please.
Thank you.
Thank you. And you have 15 minutes.
Yeah.
You change your...
Deadly. Lost mine. So there we go. Thank you very much, Professor Acconci, for your kind introduction earlier on. I also want to thank the Faculty of Law and the University of Trento, and in particular, of course, Nino, Sondra, and Marco for the kind invitation. I applaud your decision of organizing this conference on this extremely topical and well-timed theme. So following Nino's presentation, just now, I brought us up to date with the latest development in the area of investment screening. I want to take a step back and ask why. Why do we need investment screening? Because frankly, we didn't seem to need it until quite recently, at least in many countries, or specifically not at the European level. So how can investments from other countries be a harm to the nation? And what I want to do is to start off with some examples of highly publicized cases of mergers and acquisition cases, M&A cases, to illustrate the risks involved. So what are the risks? Yeah, let's take a few examples. KUKA AG, it's one of the more famous cases of investment screening. It happened in 2016. KUKA is a German robotics firm that was taken over by the Chinese firm Midea Group for a considerable amount of money, and there was no screening. The investment was not blocked, and eventually the technology was transferred to China, and the staff in Germany was laid off. The KUKA case was considered to be one of the impetus leading to the legislative process that eventually gave us the FDI screening regulation. Fast forward to last year, CureVac made headlines in 2020, CureVac being one of the companies that developed and still has a vaccine for COVID-19. And this made headlines because of the unconventional way in which the company was sought to be coming under the sway of the United States through a personal meeting between the CEO of this company, who was let go quite soon afterwards, and Donald Trump. And then finally, just I think a couple of weeks ago, the president of the Italian Republic, Mario Draghi, blocked a transaction by Applied Materials Italia, which is a subsidiary of the US firm Applied Materials Inc., through a quite complex buyout joint venture happening at the Hong Kong branch of Applied Materials in connection with a Chinese acquirer. So what do these three different examples have in common? And how can we deduct from this that investments can be harmful? And if they are indeed harmful, why do we need necessarily investment screening to address this issue? So usually, until recently, this was a question that wasn't really asked. Whenever risks were brought up in connection with foreign investments, it was usually perceived from the prism of the foreign investor. The foreign investor may take economic risks by investing in a country, or political risk indeed. But the discussion and narrative was not surrounding the risks to the state, the host state. In fact, indeed, foreign investments are quite beneficial to a country. We should, at an occasion like this, remind ourselves of that. A plentiful supply of capital reduces the funding costs, the cost of raising capital for businesses. It's also represent a welcome inflow that can help countries that are net importing, and actually the inflow of investment capital can, in that say, offset outflow of imports. And there are exceptions, and there have always been granted that there are some exceptions, and one of these exceptions are obligations relating to the investor. And examples of this also can be seen in investment treaties. There are transfer fund provisions in most treaties, and these fund transfer provisions include certain exceptions for where money can be blocked from being repatriated. And it includes usually things that have to do with the enforcement of domestic law, including bankruptcy, insolvency, criminal law, environmental laws, and so on. So you might ask yourself, why are not domestic laws that target prohibited, what we decided to be prohibited conduct, ex post? Why are that sometimes not sufficient? Why do we need sometimes to act ex ante and block certain future investments? And this, I think, is a meaningful approach to understanding what the risks involved are. So what we need to understand as lawyers is what is security, what are security threats, and what are security risks. And the concept of security, which already Professor Ali mentioned in his presentation, it's a political concept. We can see from lawyer perspective, it's a political concept. It certainly is a concept that is not a legal construct. It interfaces with the law, and it is at the heart of what I call law and geoeconomics. It is in fact, the study of security and the study of security risk is a field of scholarly inquiry on its own. So in order to understand this, let's import a few lessons from the theory of economic statecraft, the long line of literature that by now has accumulated on the topic of geoeconomics. And the first idea I want to plant with you is the idea of security as an externality. So what is an externality? Well, if you have studied economics, you might be familiar with this term. And an externality is essentially a negative impact that one party's conduct has on through its actions and omissions on the situation of a non-obliged third party. So examples, pollution is a typical example of externality. Externality cause what are called market failures, which means that basically economic transactions themselves, left to themselves, will not produce efficient outcomes. And it's also therefore a recognized exception to, I would say a recognized justification for government intervention. And so, in other words, by viewing security as an externality, as is done in the geoeconomics literature, we recognize that there is an exception to the economic logic that otherwise justifies openness to foreign investors. The next little nugget is that I want to pass on is that the idea that harm to national security is very difficult to undo. It's in that sense quite different from some of the other situations where investors may be liable for different things. Because when they happen, there will be no way you can redress it. And what can that, for example, be? It can be when access has been given to certain types of data, when a foreign state has the ability to deny host states' capability or reduce its resilience to certain outside effects, or when a third country is able to build up capabilities that it didn't have from before and strengthen its own resilience. So, and this is the third point, why bother, you know, why bother? Why not assume, as we actually were able to do for a very long time, that, you know, why don't let fair play win? Why don't let states just go after maximizing their wealth, maximizing the GDP? Why would they want to hurt each other? Well, we need to understand the underlying assumptions here. And one of the most important ones is that equality of economic opportunity, which basically permeates through international economic law and investment law as well, is a political choice. It is a political choice. So I think that needs to be understood. It isn't a law of nature. The other thing is that public interest, that states act in the public interest, is also something that is not always the case. And there are many countries are able to pursue policies contrary to public interest for an extended period of time. And the final one is that power is not Pareto efficient. What does it mean? It means that in economics, I can increase my wealth. Nino can increase his wealth without anybody else getting poorer. But power is not of that nature. One cannot be more powerful without someone else becoming less powerful. So what I'm going to do now is just briefly give an overview of the paper that I'm writing. So if we accept the premise that security risk is only manageable ex ante, and arguably, we have no choice here because investment screening laws are drafted this way, then the logical next step is to ask how to best manage that risk. And that is really the essence of law and geoeconomics applied to this question. And there's obviously a great deal that can be said, but I will limit myself in the next few slides before summarizing with mentioning two. One is the risk attributable to the nature of the investment, and the second being the risk aspects attributable to the identity and characteristics of the investor. So let's start with investment. So adversarial capital is a term that's used in this context to describe the use of foreign investments as a geoeconomic instrument. And there are two things that we need to start realizing. The first is the idea of criticality, that there are certain types of investments that would harm a state if it was denied the ability to have it in a crisis. That involves infrastructure, technologies, inputs of different kinds, so raw materials, but also water and food, data. You know, you can talk for ages about that. And finally, also to have a free and plural media. And the other aspects of the aims of the investment, right? So economic theory assumes that an investor is profit maximizing, but that's not always the case. The other factor, and I'm happy to take questions for more details of this, relates to the investors. So one category involves sovereign investors and sovereign-driven investors. I want to make this distinction. Sovereign wealth funds and state-owned enterprises are a very simple example, obvious example of sovereign-driven investors. Sometimes they can also be categorized as sovereign investors. And the other category, which is much more difficult to pin down, is what is called public-private agency. And this deals with sovereign subsidized private investors. And now we have a legislative process to have a anti-subsidy regulation at the EU level. dealing with that. The other, which is still more difficult to pin down, is sort of sovereign influence private investors, which is influenced by other means than something so easy to find as a subsidy. And then finally, a sort of a hypothetical category yet to be fully conceptualized is the idea of sovereign influencing private investors. This is the case, may arguably possibly in Venezuela, where when you can argue, is it the government that controls the oil company, or is it actually the oil company that controls the country? So I will give you at the end not my conclusions, but my challenges still to be addressed in the paper. And the first thing that I also want to have as a sort of take home from this is power as a security as being understood as not a delimitable concept, but as power uncertainty. So we need to again familiarize ourselves with the concept of power and future uncertainty. Security is more a method and a process. It's not a concept of definitive substance. So, and you mentioned that the broadening of this concept, I would say, yeah, you can say it's broadened, but it's forever broad, and it's just given more, it's just an example how this process is given forever new permutations. For more than 20 years, we've had a concept like food security, human security, cybersecurity is also a concept. All of this, just to understand that the breadth of the concept is infinite in a way. It's not what defines it. What defines it is the method. What is the tension between a security and the rule of law? Is there even a role for law? What's the role of law in this context? This is also something I need to engage with. And that is also because, for obvious reasons, security is not a matter that courts are likely to want to deal with. And when they do, are inclined to defer very much to the executive. This, of course, as we all know, also has a parallel at the international plane. Security risk versus the risk of security abuse. This is something we need to understand. So security risk is what I have talked about. But then the flip side of this is like, okay, if there's no accountability, if there's no scrutiny, if you can't go to court, there's obviously a risk that security is being abused for protectionist purposes, for various nefarious purposes. How do we deal with that risk? Yeah, and looking at the two risks, the risks of having security, a security breach, or the risk of having a framework in place that could be abused, which of these risks is more readily prevented? Which of these risks can be managed? And finally, are these risks even capable of being, insured? It might seem strange, but why not? We have anti-terrorism insurance. There is political risk insurance, of course, investment insurance, and as I mentioned yesterday, we've also done some research on investment screening insurance, which also exists. So can we then ultimately decide which of this risk is easiest to deal with, cheapest to deal with, and may that give us some inkling of how we are going to strike the balance between having a security framework that protects versus having one that could potentially be abused. So I'll stop here, and I very much appreciate the 15 minutes or maybe 16 that I've been having to talk about this. Thank you so much.
Thank you.
Okay. For your insightful presentation from this perspective that is not really our traditional perspective. I mean, as far as we academic scholars of international law are concerned, and for keeping in time limit you two. So now it's time to give the floor to our online speaker, Francesco Salerno. I think I can see him. Hello.
Good afternoon. Can you hear me?
Good afternoon. Hello.
Yes.
So good to see you, and you have the floor. Thank you.
Thank you. Thank you to the organizers for having me and for having me online. I couldn't forego the pleasure of joining this discussion, at least for two reasons. One is that perhaps I provide a view from the trenches more than from a university, in the sense that I'm practicing lawyer, and one of my field of practice is precisely Fdi screening. So one thing I'm going to try and do is to share with you, in a way, practical experience. And the other reason is that at the same time, it is a rare and privileged opportunity to step aside from the day-to-day routine of preparing filings to the presidency of the Council of Ministers and reflect with you about the bigger trends. I also congratulate the organizers because the setting of the panel couldn't have been better for me, in the sense that I can happily piggyback on a number of things that Nino and Jens have said before me. Because really the paper I would like to write, that I'm not writing, that I would like to write, really starts from where Nino and Jens have left it, in the sense that my starting point is the EU FDI regulation, which is clearly a brainchild, if there's one, of geoeconomics. The Commission has made no mystery of it in its first report on the application of this regulation, which Nino was going to allude to, published just a few days ago. The Commission, one of the statements that I've taken away with me is that the Commission strongly expects all member states to have FDI screening in place, precisely to combat the potential externality of having gaps in FDI mechanism in one member state. So FDI, the EU FDI regulation has clearly been a big boost to national FDI screenings to actively operate. And the pandemics has combined with that effect in a way to have aggressive enforcement of FDI mechanisms. And the two together really have put pressures on many national member states to screen and block transactions, at least for two reasons, which are very apparent from the way the FDA regulation is set out. One is because of the list of screenable transactions. Now there is a list, which is out there in an EU instrument that essentially have made national list of screenable sectors longer. So more transactions have fallen within the scope of FDI screening mechanisms. And the other institutional feature is the coordination mechanism. It is clear that once you file a transaction in a host state, the fact that that state is going to receive comments from other member states obviously enhances the possibility that concerns may surface. So this is the state of the state of the art of this field of law, where the chances of having transaction blocked through FDI regulations has increased due to the pre-existing factor of the EU FDI regulation and this boosting effect of the pandemics. So what I tried to do is then to look at the data. So if we take a look at outcomes of FDI in 3 member states, do we see this increase in numbers, which is a potentially, what one can take away from this combined effect of these two forces? What I'm going to do is to share a few slides with you of what has been, the first outcome of my first screening. Let me share this with you. So I start with Germany. I've taken Germany, France, and Italy, the proponents, as Nina was saying, of the FDI regulation. So I think it's a good sample of countries. And I've tried, for each country, I've tried to do it before and after COVID. So before COVID, Jens already mentioned KUKA, which was a case of a transaction allowed, which started the entire process. In the same year of KUKA, there was a transaction blocked in the electronics field. The acquirer was a Chinese buyer. And another transaction blocked a couple of years later, and I think it's consistent with what Nino was saying, that this is the peak of the time of foreign investment into Europe, 16 and 18, in the fields of metal components for critical, let's say, critical industries, aerospace and nuclear. Again, the acquirer was a Chinese company. Let's see what happened after COVID. So we see a transaction blocked in December 2020 in a field related to defense. The buyer was CASIC, a Chinese company, SOE. And then, and I thank you, Jens, for that, the CureVac episode, of which I would like to just underline the peculiar from FDI setting of a transaction never notified, but still in a way blocked. I thought to dub it, the souffle effect, or something. There was a lot of hype around this transaction. Clearly, March 2020, peak of the pandemic. This was a company active in vaccines, and then nothing happened. You pinch it, and then as a souffle, it goes down. But this souffle effect, as you will see, is not typical of Germany. In fact, it's also present in its homeland, France. So let me move to some data about France. I have to say it was very hard for me to get data for France. There's nothing published. I use Lexology as my database, and even they couldn't come up with anything other than this transaction. It's in the defense field. It was blocked in March 2020. It also had a follow-up, and I think it resumed and was completely blocked then in December 2020. So I risked of having nothing in this field of before COVID if I had attributed to December 2020. So bear with me that I categorize this as a before COVID transaction. And after COVID, we have to me at least, a quintessential souffle situation, a transaction announced by a Canadian firm that wanted to buy a national champion, maybe Carrefour. This transaction was never notified, didn't need to be. The French minister, in a very elegant way, wrote apparently a letter to the company saying no merci, and that was it. This never came about. Let's go to Italy, for which the data is featured for a number of circumstances, proximity with the sources, and also ability to search, in the language. And Italy gives us, a richer data set, indeed. So we had the transaction blocked in 2017 in the defense sector. We have the Vivendi team transaction, actually allowed with conditions, hinging again on the defense aspect. And then there was a stream of cases on 5G, very interesting. There was a completely new set of provisions inserted in the body of the Italian FDI rules. One of these transactions has been blocked. Let's go to the after COVID situation, which we all very familiar with probably because it was in the newspapers. One transaction blocked in April, semiconductors. One transaction blocked in October. This is very interesting, about agri-food by Chinese company, Chinese giant Syngenta. And then very recently, this other transaction to which Jens alluded, also blocked. So what are the takeaways and what is the answer? Do we see really this huge uptick in the number of transactions blocked? Sorry, apologies. I have also this example of this Italo-French case. It has to do with Iveco and an attempted takeover by a Chinese company. Also a, let's say, souffle episode, because this was quickly abandoned. And again, the French minister happily tweeted that this was a successful example of cooperation between France and Italy avant la lettre, in the sense of before even the treaty that was signed a few days ago. So here's the first part of the answer that I'm trying to give. This is a chart that I took from this first EU report on Fdi screening. This assigns a 2% to the number of transactions prohibited of the ones that have been, of course, collected in this report. Obviously, this report only covers the COVID period, so it is not fully relevant for the type of question we are trying to address, the intertemporal comparison of before and after. But I think it's already indicative of a trend that the pandemic, precisely because it was something that, coupled with a trend already existing, hasn't really produced this huge number of transactions blocked. And why is that? And my second level of thinking is, let's try to look a bit closer at the type of transactions we have seen together and try to categorize them. I think the first thought is that the transactions in the defense sector, those are kind of immune to the impact of the pandemic. This is a layer of transactions which, regardless of the pandemic, perhaps even regardless of the FDI, are always going to be sensitive. So the IMST case in Germany, which was after COVID, probably would have happened even before COVID. What this is perhaps more pandemic related is it's clearly, to me at least, the CureVac episode, because it directly linked to the type of threat that the pandemic has posed in terms of accessibility of vaccines. So that is probably something that is directly related to the pandemic. There's something else that I think the pandemic has brought to FDI, and it's not a transitory. It is the perceiving food security as a risk, in the sense that supply chains can be exposed when they are moved to countries that one may consider not reliable. So Carrefour and Verisem, perhaps more prominently as examples of transactions being blocked, those are a byproduct of this heightened awareness that when we move supply chains in the food sector outside of Europe, there's a food risk that perhaps we didn't perceive so high before. The last thing I wanted to share with you is that this 2%, this very low number of prohibitions, perhaps have to do also with the adaptation by deal makers. I think that there's a process which started already with the Fdi screening regulation, by which deal makers are able to understand better what was vaguely perceived as a political risk. A political risk of doing business in a certain country has always been there, but it was just difficult to pin it down, to think in a coherent way about it without being an insider to the political circles. Now, I think one of the great benefits of the FDI regulation has been to boost transparency about the way elected officials think of security risks when they run FDI screening. And that has helped deal makers to self-assess what is that risk. And perhaps certain deals have not left the boardrooms precisely because now there's a way to think more structurally about this type of risks. So this may explain why we don't see huge numbers of transaction blocks, even after these two forces combining to push exactly in that direction. So I think I leave it at that, and I'm very happy to have your thoughts on this few outcome of my very first research. Thank you.
Thank you very much for your contribution and for keeping in time limit. I ask the permission to say that we will close this session about 3:45 and not earlier, because we started a little bit late, so we have still time. Okay, Tarcisio, relax. And so now you have the floor, and then we will still have our Q&A session, of course. Thank you very much.
to the application of these legal instruments. And this is why they are discussing the possibility of opinions. We have already guidelines, because the elephant in the room is the political character of these decisions and the predominant role played by political notions, starting with national security, essential interests, and so on. So the legal framework perhaps is relatively simple. We have a clear pattern, relatively simple legal instruments, but no shortage of challenges. First of all, the definitions. There are a proliferation of definitions, but all of them are very difficult to clearly understand. The remedies is a huge problem because, of course, we need effective and independent remedies, and everybody is emphasizing the need for non-discrimination, which is very difficult to apply in this context. Then we have a problem of public scrutiny and a number of other problems. For instance, the need to strike a balance between transparency, which of course is referred to in all these documents, but also confidentiality, which of course is a big issue given the nature of the measures. In any case, screening is not a new phenomenon. And already in the 90s and before the 90s, it was almost a prerogative of developing countries. Then also developed countries and the United States in particular started to introduce screening, but as Nino said, was mainly associated to military issues. So military issues, defense, infrastructure, cybersecurity, a rather homogeneous category. Now we have the explosion of the concept beyond military issues. So we have strategic infrastructure, strategic sectors, artificial intelligence, data, public health, public order, and so on. But the evolution was well underway before the pandemic. And the concept of essential interest of states was in evolution. And a good example is the Continental versus Argentina case. So the pandemic simply accelerated the process, which was well underway before, both quantitatively, because now we have a large number of states which have adopted this kind of measures, but also qualitatively, because we have now a large number of sectors affected by screening. States have lowered the thresholds, and we have a proliferation of the triggers for screening. So I'm not qualified to summarize the excellent papers, but perhaps I will reiterate a couple of key points and try to put everything in context, because I think the speakers made an excellent job in setting the scene. I may add some contextual or systemic considerations. First of all, this is not just a matter of investment. So we have now a growing importance of national issues also in trade law. In the past, Article 21 GATT and national security was relegated to a very short paragraph in textbooks. Now the importance is growing for different reasons. We have a case between Ukraine and Russia, and with bad or good intentions, rightly or wrongly, national security has been invoked frequently, especially during the Trump administration. The second systematic consideration is that screening, of course, concerns the admission phase. Doesn't matter whether the state has provisions for pre-entry or only post-entry investment. So screening is only one of the instruments states may resort to in order to protect national security and essential interests. And today, legal instruments, and especially treaties, are increasingly frequently concerned with measures states may adopt on security grounds. And again, another analogy, we have an extension of the notion of national security. We have the frequent inclusion of clauses, general clauses, sometimes modeled after Article 21 GATT. And there is a trend to increase the level of deference. For instance, the recent treaty between Japan and Argentina is simply copying the model of Article 21, that so states may adopt the measures they consider, which means they're not entirely self-judging, but the level of deference is extremely high. The next consideration is probably the most important one about sovereignty. Everything evolves around sovereignty, national sovereignty. You just need to look at the declarations by governments or the European Union Commission. And of course, foreign investments can be considered a kind of legal earthquake because it revolutionized the legal framework. And of course, now central is the legal relationship between a sovereign state and a private entity, the investor. And states were prepared to make huge sacrifices. And of course, to make standing offers concerning arbitration. So they are prepared to expose themselves to arbitration and to allow investors to go directly before an investment tribunal. And the investment tribunal were able to deliver a final and binding decision without appeal. States were even prepared to renounce to any form of control with regard to ICSID, with regard to recognition and enforcement. So the state ICSID members were prepared to recognize awards rendered by ICSID tribunals as they were decisions, final decisions rendered by their own national tribunals. So states gave away a lot, and it was really a legal earthquake. Now we have a series of aftershocks, and the system is trying to readjust. The process was very fast and irregular. Very often, the process is not a linear trajectory. So the system needs some adjustment and is already going through a process of reform with regard to the content of treaties, the safeguard of regulatory powers of states and arbitration. And screening can be seen as one of these aftershocks after the big legal earthquake. And by screening, states are taking away, are reasserting their sovereignty. So on one hand, they are exercising an effective political control, and on the other hand, they promise to respect the basic assumptions behind foreign investment law. So they promise to do that respecting the basic principles of due process, non-discrimination, and so on. Of course, the basic assumption behind foreign investment law is to attract, facilitate, protect, promote foreign investments without compromising the capacity of states to exercise their sovereign prerogatives. States have a right, but also a duty to act in order to protect public interest. And of course, the pandemic has moved the focus on public health. So screening is part and parcel of the big picture. So states are reasserting their sovereignty in order to be able to effectively protect public health. At the same time, they promise to comply with the basic principles which are now consolidated in foreign investment law. So basically, it's a need of drawing a line. States are feeling the need to draw a line between acceptable for the investments, which will be admitted in accordance with the relevant legal instruments and entitled to the legal protection provided for in the legal instruments. And on the other hand, investments which are not acceptable. And because they undermine the basic interest, the security of states. And it was underlined by the three speakers, the political dimension, the risks, which is unavoidable. So the real challenge is to ensure that this exercise of states, these political measures based on political assessment, which can be different in different jurisdictions, will take place in accordance with the basic principles, and investors will be able to rely on effective and independent remedies. This is the big challenge, I believe. Thank you.
Okay, thank you. You were very successful beyond any time constraint to keep in time. So thank you very much. Before opening the floor to you all, I would like to ask the speakers, probably Tarcisio, probably, or Nino are most affected by my question, probably. That is, so in your opinion, these screening mechanisms are going to politicize even more the international investment climate for investment in this at this time. And we already saw an increase in politicization before the COVID-19 pandemic. So what do you think we might expect, apart from possible cases related to the domestic non-discriminatory measures, anti-COVID, I mean, measures due to the pandemic? Because of this screening mechanism, we might have cases before arbitral tribunal, but if these mechanisms bring about politicization, I would say that in reality they prevent cases somehow. So they expand the margin of appreciation of states and somehow deal with the famous discretionary powers of arbitrators by, I don't know, by making them less effective. I don't know. What do you think about this? This is it's my impression from listening to you during this panel. Thank you very much. No, I mean, just an exchange of view very quickly. Don't worry.
Logically, we should start with the speakers.
Yeah. So let me say, there is something which is very important. The first thing, when you adopt an Fdi screening mechanism, yes, you may consider the data. Data are fundamental, no? You start an analysis, but there is a phenomenon which is called deterrence. Once you adopt a screening mechanism, if the screening mechanism is very, let's say, tight, at some point you simply don't have data in the sense that you stop to invest somewhere. So not always the cases that are pending before a judge or a tribunal or before an administrative body can tell us exactly what is going on. And also we have a problem of data in the sense that it's very complicated to understand the real effects of screening mechanism, so different screening mechanism at national level. There was a recent study of Banca d'Italia, for example, but the set of data is quite limited to 2018. And they say, well, we had effects, but the effects of the screening mechanism were not so, let's say, harsh to the point of blocking, because on the same at the same times we have new screening mechanism, but also more transparent screening mechanism. So on the one side, there is a certain compensation. On the other side, let me say something. We have at the moment a quite curious effect, which is on the one side, the reform of CFUs at US level. If you have a look at the CFUs, this is the FIRMA, the famous modification in 2018. If you have a look, I started to check and try to find two words. One was allies, and the other one is cooperation. Okay, here, quite clearly, United States required the other allies, and don't forget the 75% of all the investments in the United States are of allies, okay? So Switzerland, Canada, Europe, etc. And they ask, please adopt a screening mechanism trying to have a look at ours, okay? First thing. Second, in 2019, we had the new regulation 452. And we can read in the screening mechanism, plus in the communication at the end of March 2020, quite clearly the Commission saying you have to adopt a screening mechanism. So at the moment, we have at least 2 blocks saying we have to adopt everybody a screening mechanism. And this is, according to me, something that we, as I said also before, we are going to see for decades. So the real issue at the moment is trying to, at level or at OECD level, mainly, to exchange practices so that we will have some kind of coordination on what is transparency, deadlines, and actually at the end also about how much the state should invest in those screening mechanisms to avoid a certain restrictions of the good investment. That's the real issue. To the point that if the mechanism is so transparent, we will not have a drop of the investments because of the screening mechanism. That's all. But still, there is a huge problem, and you can analyze that reading many papers that were prepared not by lawyers, but by experts in the field, in the political science, but mainly of economics. It's very complicated to analyze data. We have a problem with data. That's all. Thank you.
Okay, thank you very much. And Francesco, would you like to add something, please?
Well, thank you. I was intentionally vague about remedy. I didn't qualify whether it was international remedies, arbitration, or domestic remedies. But if you ask me, I think the big challenge would be domestic remedies, especially when, for instance, in a treaty, we have protection only for post-entry phase. So in this case, the investment is admitted in accordance with the law and regulations. So if the state can exclude an entire sector or can subject the sector to an authorization or a license, of course, can also introduce some form of screening. At that point, I don't think the investor can invoke the treaty. Different is the case in which the treaty provides for pre-entry. Then at that point, screening may come into play in the pre-entry phase. So in this case, the investor can complain about discriminatory measures or national treatment or arbitrary measures, etc. But I think the real challenge would be domestic remedies, public scrutiny on one hand, and domestic remedies. So since states are very clear, they want to protect their own national security, and they are obliged to take these measures, which are, we have a huge number of investment which are screened, but very few measures concretely adopted. So on one hand, states are claiming the right to select and screen, but at the same time, they want to keep attracting and protecting for investments. So they must provide remedies at the domestic level. Of course, we know that remedies may be different in different jurisdictions. So there will be a price to pay if the state introduces screening measures without providing effective remedies. So in this case, will not be attractive anymore.
But it's a sort of a preemption of international investment arbitration we might see in the future. I don't know. Anyway, thank you very much. And it's time to open the floor to you all, and raise your hand, and please, okay, wait for me to point to you, but please, Professor Gattini from the University of Padua, please. And Francesco,
Francesco,
yes,
do you want to say anything?
Would you like to add something?
Anything?
Can you wait a little bit more?
No, thank you. I'll take questions. Thanks a lot.
Okay, thank you.
Yes. No, I was thinking to give them the floor.
Okay, thank you.
So,
Thank you, Pia, for giving me
please.
the floor. So I am Andrea Gattini, professor of international law at the University of Padua. So my question is directed to Nino, but actually to all the speakers, and has to do with the definition of national security You touched upon the point that is a very delicate issue, a very uncertain one. Tarcísio spoke even of political decisions. Professor Paul spoke of risk of abuse of security. So my point is, I think that the regulation 452 is extremely weak instrument. Actually, it's really the bottom line, and the European Commission has practically no power at all on point of deciding. Well, yes, giving advices and so on what the state thinks is really a matter of national security. So I think that a way to go a little more forward and not to fall back on the bottom line of the self-judging clauses or whatever, which is really for European standards is a sign of really of a failure. I couldn't understand that the OECD, so many states are not able really to define, to have a common position, but the European standards is, well, lamentable. So I think if a way out for the European Commission to circumvent a little bit this problem that is not really a competence in deciding what national security matters is, could be the draft proposal, the recent draft proposal on the regulation on the merger and acquisitions about merger and acquisition with the participation of foreign companies benefiting from public subsidies. Do you see a link between this draft proposal where the European Commission would have the competence to decide if to allow or not for the acquisition, for the merger, is a way to circumventing a bit this problem of giving a common definition of security, national security, which by now we should consider European security matter. Thank you.
It's a interesting and also complicated question, but let me tell you something that maybe I have a little bit, well, it's a little bit different, my position on the powers of the Commission, because especially in the field of Article 8, no, the European Union interests, they say that if the state is not going to follow the opinion of the Commission, they should motivate deeply, okay? Let me put it in this way. According to me, it's a strange way to arm an opinion which should not be binding of the Commission. In other words, if I'm not going to motivate in a correct way the reasons why I'm not going to follow the opinion of the Commission, I think there are margins for the Commission to bring the state before the court with the infringement procedure, which is very also a delicate issue, because let's not forget the fact that the opinion should not be binding. And actually the regulation has given the power to give opinions, but the state should motivate in a detailed way if they are not going to follow. So it's like they constructed an opinion in a way so that they armed the Commission to bring the case before the Court of Justice. So I wrote that in a recent article, but I mean, I think there are good margins for the commissions, but I know that it's a strong political thing. About the concept of national security, there is an ongoing discussion at the moment. Even the European Parliament, for example, in the field of data, proposed to discuss with to discuss with the United States, but the problem in the United States is that there are 16, 17 intelligence agencies. So when you talk about national security, yes, they have a problem of, for us, I mean, who are we going to call to discuss about national security? And the problem is that the correct way to avoid that the national security is a so wide concept so that it's just political and any politician could feel that, is that we start really to discuss about the boundaries. And if we connect the concept of national security with sovereignty, the fundamental elements are always there. It's hundreds of years that we are talking about national security in connection with sovereignty. It's population, it's the government, it's the territory of the state. If those things are touched in a way or the other, the national security of the state is touched. In other words, if the main components of the state are in a way or the other touched by the other one, that's national security. In other words, there could be, for international lawyers, a way to discuss about national security to construct a concept which is linked closely to the same idea of international law and to sovereignty. So yeah, it is actually a huge problem. It's a huge problem because we have too many documents, including the European Union Treaty. Article 4, paragraph 2 says clearly that the national security is a responsibility of the member states. So, and that's also why Regulation 452 is weak. It's weak because we have, on the one side, an exclusive competence of the European Union, which is common commercial policy and in particular FDIs. And on the other side, we have an exclusive competence, the only exclusive competence, which is already, I mean, in the treaties in Article 4.2, which is national security. And that's why it's weak. It's weak because it's complicated to stop the states. Let's not forget that there are even states like Italy, which oppose a lot the regulation for the exchange of data because they considered many issues a matter of national security. So it's still an ongoing discussion about that. But I mean, I appreciate a lot your question, but maybe I would need days to answer in a complete way. Thank you very much.
Okay, thank you. Other questions from the audience? Or comments from, okay, please introduce yourself. I'm sorry.
Yeah. Good afternoon. My name is Massimo Boschi, and I am only a PhD candidate in the University of Bologna. First of all, thank you for this opportunity. And then my question, and sorry for my question because I usually talk about these issues only with myself. I noticed, and I don't know if I well noticed, two different trends in the national security jurisprudence in trade and in the national security jurisprudence in investments. In particular, two different trends linked to, on one hand, the consideration of economic crisis as national security issues. That in investments, it seems possible. On the contrary, in the trade environment case law, and I'm thinking about the two panel reports, WTO panel reports in 2019 and 2020, these possibilities seems impossible. On the other hand, I noticed that in investment case law, the discourse is also focused on the necessity on the concept of necessity. On the contrary, in trade case law, this is not the case, in the sense that panelists usually referred the verb consider, enshrined in Article 21 and in general in all national security exceptions, to the adjective necessary. The state considers necessary, and in considering it could consider everything. So my questions are, what's your opinion on these two things, and in particular, if the concept of necessity is the juridical concept of necessity is linked to the adjective necessary enshrined in security exceptions. And on the other hand, if we should expect some cross fertilization between investment case law and trade case law on national security. Thank you so much.
Thank you very much for your question. Who would like to reply? Francesco, you might have, no, Francesco.
I can
Yes.
Since
Tarcisio first.
I mentioned my point was a general one. So I just wanted to underline the fact that national security, essential interests are increasingly important, not only in investment, but also in trade. Methodologically, I would be much more cautious in comparing the two, simply because we have a variety of provisions in investment treaties. So it's difficult to take investment treaties as a unique block. We should take each treaty individually and carefully study the provisions. So all the provisions you mentioned, they're different in different treaties. Okay, so we can have a single argument for trade, but with investment we have a very fragmented framework. So individually taken the treaties. Okay.
Thank you. Would you like to add something if there are no other questions?
No, cross-fertilization, more than that, because many investment treaties are expressly referring to articles of GATT, mutatis mutandis, or directly incorporating the GATT. And in some European treaties, the treaty provides that the arbitral tribunal should take into account also the jurisprudence of the panel and the body. So more than cross-fertilization.
Thank you. So, yeah, or Francesco, would you like to add something, a remark, a comment?
Yeah, I'm happy to do so. I think that so considering the question we received earlier, I think that the fact that national security is a very open and broad concept, and that courts are not very eager to pin down its exact meaning, I think is there for a purpose. And I think that states are unwilling to agree to exhaustive definitions of what their national security interests are, because they would tie their hands. I don't think that so it's not a legal argument, it's a political argument. I don't see it politically, going to happen like ever, that states would want to totally exhaustively define its national security interest. Nor do I think it's really realistic in a European setting that that member states would, at least today, hand off the power to screen investment to the Commission. I think it's quite different from subsidies. Subsidies is much more comfortably within the framework of trade, common commercial policy, but securities, I think, for the time being, a no-go zone. But who knows? Maybe it evolves differently.
Okay, thank you.
Maybe if I can just follow up on that remark, just to react to this debate. One is one comment about the coordination mechanism, and what also Nino was alluding to. I think it is a huge step forward that the national officials in charge of FDI have to wait for other member states or the Commission to send comments. From the daily experience, the perception is that this is a necessary complication of something that they used to run in their silos. So I think with the FDI and the coordination mechanism, I think we've made honestly a huge step forward towards having a European dimension already. If we can go further, I don't know, everything is possible in a way, but at the same time, no, not everything is possible. And what I mean by that is that on national, the only thing I would say on national security, of which I'm no expert at all, is the following: that Mr. Vestager cannot make the same type of declaration that the French minister has made when he rebuffed the attempt of a Canadian investor, simply because she is not an elected official and the other one is. So what an elected official can do about national security is one thing, and he's even in a way even obliged to do what he did, because it is up to elected officials to discuss national security. It is something completely different what an unelected official can do. And so when my example is, if you ever ask to Ms. Vestager to take a position on a merger proceedings, she will always say, I need to consult with my services. My services are doing the job. And then she will deliver the outcome of what we know it's a, let's say, technical job within the margin of maneuver of the Commission. So that is the comment I wanted to make there. Thank you.
Okay, thank you very much. There are Jens and then Nino that would like to say something.
Sorry,
Yes.
I'm
No,
a
it's okay.
slow starter, but now you're triggering me here. I just wanted to add to what Francesco said. I totally agree that the cooperation mechanism is the way forward. They could be made much more efficient than it is today. And in the working paper that is appended to the report, the annual report that came out only for a few days ago, there's a lot of interesting remarks from the member states, how they complain about actually how it works in detail. So that can be improved. The Commission can have a bigger role. I think that, and I want to clarify my comment before, I don't think that the member states will ever give away the right to screen and decide to the Commission, but it's possible that the Commission gets its independent additional right to intervene. That I think doesn't necessarily deduct from the powers of the member states in the same way. Finally, a much bigger problem in a way, and I think it was alluded to both by the comments and as well as from Francesco's presentation, is what you call the souffle effect. I think it should not be underestimated. In many cases, it's just not going to happen that an acquirer bothers to go through a lengthy court procedure when the court procedure may be more if there is any commercial rationale and simply a delay by investment screening already makes the investment unattractive, they might just go to the next company and try to buy that one instead of trying to get the justice through years and years through the court system. So maybe what would need to be considered are other remedies, maybe not judicial even, non-judicial, like mediation, something like this. Huh? Okay, I rest my case.
Yeah.
No, it's okay. Thank you.
So.
No, fine. Thank you.
Okay, so a very little thing to add, because Francesco relaunched my intervention. And so no, in a few days, I will participate to a stakeholder European Union and US meeting on foreign direct investment screening. And there will be the US and the European authorities talking together with stakeholders about how to coordinate on this. So it's like we are watching something which is the progressive alignment in some ways of the different screening mechanisms. This is a really interesting phenomenon that we are going to see, I think. Thank you.
Okay, thank you very much. I think
Grazie Francesco.
Grazie a voi, arrivederci, buon lavoro, grazie.
Well, good afternoon, everyone. Marco Pertile. I mean, I mean, he's the organizer and he's not paying attention. I mean, the hopeless Italians. I mean, may I invoke appeal the attention of the organizers? I mean, I don't want to be the master of your business, but I'm sure that if we get started late and we end up too late, the fault inevitably falls on the chair. So Marco Pertile, you are kindly requested to take a seat and let the second panel get started. Also because once you have foreign investment being screened with all the technicalities that we have learned from panel 1, the problem arises in which you have to apply the law to the screened and admitted investment. And clearly, I remember getting involved with this, with a series of discussions on the potential impact of COVID on investment law and arbitration, potential, and COVID is still there, and the problems are materializing ever more. And the 3 basic pillars remain, which deserve our attention following the developments that are underway, in which you apply full protection and security, both ways at least, fair and equitable treatment with all the reference that will be made to expectations, how legitimate they are, due diligence, and then defenses. That's the classical issue. We have a very rich set of panelists. All those who are a little bit in the know of investment law are certainly pleased to see our panelists around this table. Therefore, I will not indulge too much in long presentations, even though we have also young, if I may say, young speaker who has quite a significant academic Latin American background, and we know how much Latin America contributes to the problems that are to be solved by ISDS and the scholarly contributions in Bogota, with major academic acknowledgements, and then his research activity currently being carried out at the University of Bonn. But like all the members around or along this table, he complements his scholarly background with interesting practical side to his scholarly work. He is a qualified abogado in Colombia, and he will speak to us about full protection and security. The next the speaker after Sebastian will be David, isn't it? No, yeah. Well, Julia is not with us. I mean, it's a pity. Is she online? Yeah. Julia will speak about the second leg of the substantive law, which is a fair and equitable treatment. Julia, I think I met Julia in 2013, precisely when she was organizing a conference on investment law and protection of the environment. That shows how foresighted Julia was already then. And I have been discussing with Julia in a number of other organized discussions on the impact of COVID on investment law. Julia is, and I can pronounce it with a certain degree of pride, the name of the business university where Julia is assistant professor at, and tell me, Julia, if the pronunciation is correct, is Nijenrode. And next to being an assistant professor at Nijenrode Business University in the Netherlands, Julia is also associate research fellow at Utrecht University. And currently, Julia is a co-director of dispute prevention program of the Asia Pacific Foreign Direct Investment Network. David Collins from City University of London. He also combines a scholarly, features a scholarly background with that of a practitioner, being a solicitor in England and Wales and admitted to the bars of Ontario and New York. And he, which is particularly germane to our discussion, is also on the roster of panelists for the former NAFTA, now USMCA. Another panelist in the roster of USMCA is Catherine, but that does not render justice to Catherine's involvement in investment law. And since her last book, her role in the general public international law discourse, I'm sure that those who have not grabbed a copy of the book yet will be keen to know what the book is about, which is the heart of international law, which is the role of equity in international law. So I would stop the presentation and I will give the floor without further ado to Sebastian. You've got the floor.
So thank you very much for your kind introduction, and may I thank also the University of Trento for this invitation. Today, I will be speaking about full protection and security and the coronavirus pandemic. And I like to start presentations about specific investment standards with an example of a treaty clause, so that we see what arbitrators are also seeing when interpreting these provisions. I took here the example of the FPS clause of the United States-Mexico-Canada agreement, which is the agreement that replaces NAFTA. And you are all very well aware of the structure of these clauses, but I want to draw your attention to a few features. First, full protection and security appears as a customary standard. So it is not only treaty-based, but it is also declared to be customary. And it is an element of the minimum standard of treatment, which historically appears as an opposite concept to the doctrine of equality. And the idea is then that full protection and security is an objective minimum that cannot be reduced to equality with domestic investors. Just keep this in mind for the next points of the discussion. So in cases concerning the coronavirus pandemic, I think that when addressing an FPS claim, it will be necessary to ask three questions. The first question is whether the standard is applicable at all in that specific case. And that question concerns the scope of application of the standard. The key question being whether the risks associated to the pandemic or triggered by the pandemic are covered by this specific standard. The second element of the discussion will be, if the standard is applicable, whether there was a breach of the standard. And that question leads us to the content of the standard, which is generally accepted to be defined in terms of due diligence. So the state is required to exercise due diligence in the protection of the investment. And assuming that a breach of the standard is established, then the question is whether responsibility attaches, and there might be reasons why responsibility does not attach in spite of the breach. The conduct of the state might be justified under specific treaty-based exceptions, such as national security, or specific health exceptions, which are to be found in some contemporary treaties, or they might be justified under the general law of state responsibility. I will focus during this presentation on the first two questions, and the third question will be thoroughly answered, I believe, by some of my colleagues during their presentations. So when we ask about the scope of the FPS standard, we need to acknowledge that there are three main approaches in arbitral practice. The first approach is to say that full protection and security refers essentially to physical security. And here we have to take into account the treaty text, because in some treaties, the physical security approach is expressly incorporated into the treaty. That is the case of the Canada-EU agreement of CETA, where the definition of full protection security limits the standard to physical security. In cases where this is not an issue. I believe that the physical security approach has a main problem. And the problem is that full protection security is a guarantee for investments. And investments are defined in most treaties in broad terms, which include non-physical assets. And then the question turns into how to guarantee physical security to a non-physical asset, such as goodwill, for example. Then we have a second approach, which is to say that full protection and security is a broad notion, which covers different kinds of risks. And in that sense, if the treaty drafters did not limit the concept, then the interpreter should also assume that the concept is broad. The problem here is that this broad notion of security is usually used to incorporate the concept of legal security into the standard. The consequence being that, for example, a legal reform affecting the regulatory framework of investment could be considered a breach of full protection and security. This leads to two problems. The first one is, what is the role of due diligence? So if we have a case which concerns only state action, then why is responsibility established in terms of a breach of due diligence, or does the due diligence element doesn't play a role in this context? And secondly, the question arises as to what is the effect of this approach on the relationship between full protection and security and other standards, such as fair and equitable treatment. There might be an absolute overlap to some extent. And there is a third approach, which I call third-party approach, which has growing acceptance in cases such as El Paso or Electrabel. And it says that full protection and security refers to the state's reaction against third-party conduct. So it refers to a positive obligation to protect investment against others, so to say. This allows a clear line, or drawing a clear line, between full protection and security and other standards, and presents FPS as a delict of omission, because the breach is established always in terms of an omission in exercising due diligence. Let's see how these three approaches might play out in the context of the pandemic. So if we were to assume that FPS refers to physical security, the fact is that in most cases, the pandemic has had an economic rather than a physical impact on the investment. So there could be claims, for example, related to physical violence triggered by the pandemic. So for example, a violent protest against pandemic related measures, which lead to violence against investment. And there might also be a door open for cases concerning physical damages to natural persons who qualify as investors. But here, the key is the language used in the treaty, because some treaties, such as the USMCA, which I quoted at the beginning of this presentation, grant full protection and security only to investments, while others, such as CETA, include also investors. So full protection and security to investors and their investments. So in that case, if we have a physical person as the investor, there might be physical damage to the investor as the object of the investment claim. If we assume a broad notion of security covering everything, then it is clear that cases concerning economic losses due to COVID-related measures might be covered by the FPS standard. And as regards the third-party approach, here you have a quotation of a classic statement of this approach. Then the question is whether the pandemic could be actually assimilated to third-party violence, because there is no human conduct intervening. And then there might be two arguments or two opposing arguments in this regard. We could say that it is a covert risk, because the rationale from the perspective of the state is similar as in the case of third-party conduct. The state is reacting against some external danger, some external threat. And we could open a similar debate as in the case of whether, for example, FPS protects the investment against natural disasters, which are sometimes assimilated to third-party violence by analogical deduction. But there is also an argument against using the standard so defined in the context of pandemic risks, since on the one hand, it is not clear whether there is sufficient state practice supporting this approach. And on the other hand, the standard is usually defined as a customary standard in most investment treaties. So these are the stakes when it comes to the scope of the standard. Let's move now to due diligence. So due diligence is a complex concept, and I will just draw some thoughts on its application in the context of the pandemic. First, as the standard is an element, as FPS is an element of the international minimum standard, and the international minimum standard is the opposite to the doctrine of equality, then due diligence cannot be reduced to national treatment, and we cannot have a merely subjective standard which defines the diligence required from the state in terms of the diligence the state exercises in its own affairs, namely in the protection of its own investors. Most tribunals accept that the standard is objective, but the current trend is to say that it is a modified objective standard in the sense that the standard must take into consideration the specific circumstances of the state and the resources at its disposal. That is also related to the idea that this is a minimum standard, so that we are not looking at what an ideal state should have done, but at what an average state should do as a minimum. But due diligence cannot be reduced to a general definition or cannot be understood to a syllogistic approach. And I believe that the best way to approach the concept is to see which criteria come into play in the analysis of due diligence. I will address only some of them. A first element is awareness about the risk. So it is a key question whether the state was aware of the risk. And we have to distinguish in this context between unknown risks and known risks. If the risk is known, then there is no question that the state was aware and should have reacted. But if the risk was unknown, then the question is whether the risk was foreseeable. And this might be interesting in the context of the pandemic, because if we follow the rationale of the tribunal in Ampal versus Egypt, we can analyze the question of foreseeability at considering the moment in which the measure is taken. In that case, for example, there were 13 attacks on a pipeline, and the tribunal came to the conclusion that the first attacks were unforeseeable, but they were a warning, and the attacks from the fifth attacks up from the fifth attack and so on were actually foreseeable, because the state was already being warned by the former attacks that a terrorist attack could occur at any time. So in this case, we could draw a distinction between measures adopted at the beginning of the pandemic and subsequent measures that might have been taken at a moment where there was more evidence and more information about the pandemic. A second element is consistency of state conduct. And tribunals have taken into consideration several elements in the analysis of due diligence. One of them is whether there were differences in the protection afforded to different stakeholders. So if the state was in the position to protect an investor, then the question is, why did it not protect the protected investor under the BIT in the same way? Another question is whether the state followed its own domestic standards, its own domestic law when adopting the measures. Possible violations of domestic law imply that the state is not following its own standards when acting with regard to the protection of the investment. And third, some tribunals have considered whether the state has complied with other diligence obligations under international law as a possible element in the analysis of due diligence. So if you look at all of these elements, there is one missing, and it is maybe the most important of all in the context of a pandemic, and it is the need to strike a balance between conflicting interests. So the state is not expected to exercise diligence in the protection of the investment to an extent that puts the investor's interest forward with regard to public interest, but it is actually granted a broad margin of discretion in determining how the investment should be protected and which measures are appropriate in the specific case. This has a potential in the case of public health cases. Now, to conclude these thoughts, I would like to draw your attention to the fact that many of these elements come close to something you are all maybe aware of, namely to the analysis of sanitary and phytosanitary measures in the context of WTO. So we are looking at whether the measure was based on some international standard, for example, whether there was a specific objective risk assessment. So in the specific context of pandemic measures, the analysis of due diligence might bear some resemblance to the analysis of sanitary and phytosanitary measures in the context of the WTO. And then the question I will be addressing in my paper is, among others, to which extent can tribunals actually draw analogies to WTO law when analyzing due diligence in this context? And the question there is whether analogies are permissible. So in favor of the analogy, we could mention that the situations are similar from a factual perspective. This WTO case law on objective risk assessment, on prevention of health hazards and so on, might help develop more specific criteria as guidance for the evaluation of due diligence. And there is a corpus of cases considering rationality and consistency of state conduct in the context of sanitary measures. But maybe there are some arguments against the analogy. For example, WTO adjudicatory practice focuses on the specific language of a multilateral treaty, and this language is not present in investment agreements. So the question will always be, to what extent can we use those criteria to apply an obligation that is not only different because it is in another treaty with in another context, but moreover is not only treaty-based, but also customary. So this will be an issue possibly when analyzing FPS in the context of the coronavirus pandemic. To conclude my presentation, I would like to say that, and I apologize for my PowerPoint abilities, that even though there might be a case, depending on the approach one follows, to say that the FPS standard is applicable with regard to measures adopted in the context of the pandemic, it will not be an easy task to win a case as an investor with the FPS standard. Because in all these cases, you have like a curtain wall, which are the treaty-based exceptions, and there are even some treaty-based exceptions in new agreements, as the Comprehensive Economic Partnership Agreement between Indonesia and Korea, which contain and which exclude, for example, health measures from the scope of jurisdiction of the tribunal. So that is like a huge curtain wall for these claims. But you have also circumstances precluding wrongfulness, such as force majeure and state of necessity. So that the state has actually like a fortress to protect itself. And in the case of FPS, you have, in addition, a mode through this fortress, which is due diligence. And due diligence grants a very high level of discretion to the host state. So I thank you very much for your attention and look forward to your questions.
Well, thank you very much for sketching out a very interesting, a very appropriate structure of analysis, which makes your future written contribution one which I would very much like to read, and for drawing the attention on the fine line when it comes to potential defenses based on the body of secondary rules on the law of state responsibility and the actual contents of the primary obligation, and therefore putting the finger into the standards of diligence due, which with regard to full protection and security are particularly delicate, but I would not say that they are not delicate when it comes to assessing the contents of the obligations stemming from the fair and equitable treatment standards, which is the next topic, which is going to be addressed by Yulia Levashova. Good to see you in very high definition there. So the floor is yours, Yulia.
Thank you very much for the kind introduction, and thank you to the organizers, and especially to Sondra, for preparing and organizing such a relevant and significant event. I'm looking at the organizers who perhaps can share my presentation on the screen, so you can see something besides my face. Thank you. My presentation will be focusing on the legitimate expectations and the outbreak of COVID-19 pandemic brought the subject of potential investment claims arising as a result of government measures under the fair and equitable treatment standard to the forefront of investment law discussions. So in my presentation, I will focus on the legitimate expectations of foreign investors and even narrowing down the focus of my presentation to the stability claim. Next slide, please. In the context of an assessment of FET standard, one of the contested issues in investment law is the scope of permitted regulatory changes under the obligation of stability. And the latter issue is particularly relevant in the framework of the possible future COVID-19 related claims. The change to a regulatory framework justified by the state response to the health crisis or its consequences can be possibly the subject of investor claims under the FET standard. And the parallel here can be made to the tariff deficit crisis occurred in many countries such as Spain, Italy, Czech Republic, Romania, and others, leading to multiple FET claims, but primarily based on the notion of stability. Therefore, the specific focus of my presentation and paper is the protection of the legitimate expectation that may arise as a result of change to a regulatory framework. So firstly, I will briefly explain the notion of stability and its limitations. Secondly, I will offer some thoughts on how various interests are balanced in investment cases involving stability. And at last, I will provide several observations regarding the potential for claims based on a change to a regulatory framework as a result of state measures responding either directly or indirectly to the pandemic. Next slide, please. As a regard to the notion of stability, the starting point is that tribunals generally agree that the regulatory framework cannot be frozen for the lifetime of investment and that the state can modify its laws as a part of the right to regulate. So this part is generally not disputed. What is disputed, however, is the extent of permissive changes to a regulatory framework and in what circumstances those changes have to be compensated by a state to the investor. And this is the subject to various interpretations. The key criterion in tribunal assessment on the question of regulatory stability is whether the change was disproportionate in the view of the impact of investors' investment and whether this change amounted to drastic or fundamental transformation of the existing framework. Next slide, please. To balance the investor interest to safeguard some level of stability and the state interest to regulate on the public welfare, many tribunals perform a balancing exercise. It's important to underline that the claim based on stability has its limitations. In more recent decision on FET, tribunals have given more consideration to the state right to regulate in assessing the investors' expectations. And tribunals have recognized that for the expectation of investor to be protected, as was put by the famous Saluka against Czech Republic case, the expectation must rise to the level of legitimacy and reasonableness in the light of circumstances. There are several limitations on the obligation of stability that tribunals tend to consider in the assessment under FET standards. And those are the existence of the legitimate state objectives, the specific circumstances in the host state, proportionality of the adopted measure, and the conduct of investor, specifically the extent of performed due diligence. And I want to emphasize that those factors are not cumulative, they rather serve as a relevant indicators that emerge from multiple FET decisions, where tribunals were required to balance the stability of investment climate and the state right to regulate in the public interest. Because of the time limits, I do not have possibility to elaborate on all of those factors. However, I will briefly focus on the existence of legitimate state objectives, very briefly specific circumstances in a host state, as well as the proportionality. Next slide, please. Most tribunals recognize a wide spectrum of state objectives taken in the public interest, and they are very diverse. Of course, the protection of public health, protection of cultural heritage, but also many others, such as the modernization of the transport sector, and many other economic objectives. The important differentiation, however, is between the legitimate and illegitimate states' objectives. The criteria for establishing the legitimacy of policy objectives are whether a state measure was directed at the public interest, first, and the second, whether it has been justified by the state through different records or other evidence. And considering the unprecedented nature of the pandemic that affected almost every person in the world, for investor, it would be a difficult position to argue that the state objectives to tackle the pandemic or its consequences have not been taken with the legitimate goal. So already at the outset, it would be an easy position to argue. However, it's important to underline that the presence of a legitimate public interest is just one of the factors in weighing the state and investor interest. Establishing that the objective of the state measure is legitimate and taking in the public interest does not imply that the reversal of the investor's expectations does not have to be compensated. However, the interesting question here is how the weight is attributed to a particular public interest. So the weight attributed to public interest objective depends on the standard of review employed by tribunals. The high degree of deference applied to the decision of the state, the more is the likelihood that the public interest behind the change will be considerably taken into account in an assessment of the legitimate expectations. In terms of public health, in a few decisions what involve the protection of public health, such as Chemtura against Canada, Philip Morris against Uruguay, tribunals tended to afford a high degree of deference to the state measures. In those two cases, tribunals stressed the legitimacy of states' objective to protect public health and the discretion of public health authorities to undertake the necessary health protection measures. This being said, tribunals have not been consistent on the role and the extent of the state legitimate objectives or public interest in the evaluation of the expectation, the investors' expectations. For example, in the several recent renewable energy decision, SPF against Italy or Green Tech against Italy, tribunals applied the less differential approach to the state objectives and questioned the necessity of the state objectives against the adverse impact on the investor, hereby engaging in a type of the proportionality analysis. For example, in the SPF case, the tribunal considered proportionality of the measure to be irrelevant criterion for the assessment of the legitimate expectation at first, but nevertheless, the tribunal still examined the state objective to adopt the disputed decree. The majority of the tribunal doubted of the necessity of adoption of the decree and providing, and I quote, that given the modest effect of the decree on electricity prices and consumption, the majority of the tribunal is not persuaded that the incentive system was at risk absent the adoption of the decree. So the level of deference that the tribunal decide to apply to national decisions determines not only the intensity of the review of the decisions of the state's authority to transform the regulatory framework, but it also attaches the weight to the state objective to regulate in the public interest and overall balancing. In Cavalum against Spain, the tribunal provided that the state has the right to amend its laws that constitute a part of the state margin of appreciation, and that the state and its regulatory action is entitled to a high measure of deference. It has to be said the tribunal did not really elaborate on those doctrines. Nevertheless, an explicit reference to both standards demonstrate the role and the weight placed to the state right to regulate by the tribunal in balancing of interest of the investor and the interest of the state to regulate in a public interest. Next slide, please. Another limiting factor on notion of stability that sometimes considered by tribunals and which might be quite relevant in the context of the health crisis are the particular circumstances in a host state. The presence of legitimate objective of the public interest should be differentiated from the circumstances that relate to, for example, economic or social political situation in a host state. The factor of circumstances is relevant in the context of legitimate expectations because such circumstances influence the general investment climate in the host state. So, for example, the economic hardship that followed the consequences of the pandemic can be the example of such circumstance. And looking at the case law and several decisions, tribunals have emphasized this element and provided that, for example, in the situation of economic crisis, such as in the case Total against Argentina, or in the circumstances of social political transition from planned economy to free market economy, in the example of Mamie Doyle against Albania, the investor cannot really expect that the state will act as it would in the normal circumstances. Next slide, please. Thank you. Another important consideration in assessment of stability claim is proportionality. Increasingly, to balance different considerations, tribunals employ partial or full proportionality review and assessing the legitimate expectations. The application of proportionalities, however, varies among tribunals. In some decisions, proportionality has been referred to, though without consistent explanation and application of this principle in the case. In some words, tribunals explicitly apply a proportionality test, however, differ regarding the strictness of this method of review. In some decisions, such as RVE against Spain, tribunals applied proportionality stricto sensu to test whether the state measure has been excessively burdensome for the investor compared to the benefits produced by the measure. It can be considered somewhat intrusive, and the intrusive nature of the later test, in my view, may not be the right method for assessing whether the state objective to protect public health was more important than the avoidance of an adverse effect on the investment. Next slide, please. So I would like to offer some concluding observations. I think I was quite quick in explaining all different elements and not all of them. So I could elaborate during the discussion, but just to say something in general, to predict the possibility and outcome of the COVID-19 related claim based on the argument of stability is of course not an easy task. It pretty much depends on the type of the measure, what I have not addressed in my presentation, and the timing of the claim. As a general observation, of course, some regulatory changes undertaken by states to address the pandemic, especially in the beginning and the first years of the health crisis, on the one hand, will likely qualify as a fundamental and transformational change. For example, in cases such as when the state adopted certainly quite invasive legislative measures which affected investors drastically. On the other hand, considering the unprecedented nature of COVID-19 emergency, the objective of the regulatory modifications and state deference to take the necessary measures in times of crisis will likely carry more weight in tribunal assessment than in other circumstances that have occurred in the past and what we have also observed in the earlier case law. In the recent FET cases, clearly tribunals have been explicit and recognizes the state right to regulate in the public interest while assessing the investors' legitimate expectations. However, the deficiency, in my view, in the analysis of the regulator stability, either is a part of the legitimate expectation or a separate requirement, because that's also discussion, of course, is not a disregard to the state right to regulate, but rather the discrepancy in how the balancing of different interests is performed. There's no consensus on how to perform the weighing of different interests, what is the appropriate methodology, and what is the proper standard of review. And I think that the COVID-19 pandemic highlighted the need to further clarify the methodology used in resolving the tension between the state right to regulate and the legitimate expectations. Further clarification on application of method and standard of review could be, I think, the right course of action. And in my view, the principle of proportionality in combination with a high level of deference afforded to the state authorities may serve as an appropriate and consistent methodological approach, especially for the cases involving a rather strong public interest as the protection of public health. Thank you very much.
Thank you very much, Julia, for a very thorough and comprehensive presentation, one which has clearly shown the very matter of fact that the applicable rules in question are extremely dynamic, very much fact-specific dependent, and perhaps having reached that result to prompt that sense of awareness. And as much as a scholar, I understand that you would pursue consistency in methodology. When it comes to applying whatever clarified methodology, the same methodology by all investment tribunals in the world, the fact-specific circumstances will inevitably prevent full predictability as to the decision, because there is always a margin of appreciation, not just on the parties, but on those who adjudicate. And I believe that perfection would be the enemy of the good. I believe it would be very difficult to find a methodology which would enable us to guess who is going to be right, wrong, who is going to the arbitrators to find for or against, particularly in circumstances of such a degree of gravity as a pandemic, in which, as it has been, I think, highlighted by previous speakers, I mean, the circumstances about the same macro phenomenon change, and the perception of the government and of the operators changes. Take these days, is variant going to be complicating things, or is this going to be the sign of the way out of the virus? Is the virus weakening and are we then going to see measures being lifted soon? Or is this a sign that the virus is not going to leave us anytime soon, which would therefore justify keeping emergency measures for a longer period of time? Now, the circumstances justifying extraordinary measures bring us to the next speaker, who, if ever a state were to be found to be in breach of primary obligations of full protection and security or fair and equitable treatment, then the big issue arises as to whether, nonetheless, the defendant state has good ground to defend itself, invoking a circumstance precluding wrongfulness, which associates very much public international law with domestic contract law. Since the beginning of the pandemic, so very many contractual disputes have been very much settled by using force majeure, and in our case, we have state of necessity. Without further ado, David, you've got the floor, and look forward to hearing you.
Thanks very much for that. And I'm delighted to be here. I really appreciated the invitation to this conference. It's so nice to be able to see people in person again. And I'm always happy to come to Italy. So I'm really glad that this was my first conference after the collapse, and hopefully there won't be another one. So what I'm going to be talking about is customary law defenses and investment arbitration. So some of what I'll say is going to overlap with what we've seen already, but I think maybe it's a slightly different take on it. So customary international law, as we know, is a primary source of international law, along with treaties and general principles. We also know that customary international law is a body of law that arises from established practices that states consider to be binding. That means that it exists even in the absence of a specific reference in a treaty. So we have the International Law Commission's articles on state responsibility for internationally wrongful acts, sometimes abbreviated to ARSUA, and they codify 6 defenses that states may invoke to avoid responsibility, referred to as circumstances precluding wrongfulness. And again, these exist in addition to defenses specified in treaties. 3 may be appropriate defenses for COVID-19. Response measures which have harmed foreign investors, and these are force majeure, distress, and necessity. I should also add that the police powers doctrine, which might be part of customary international law, might not, may also be relevant. It's all right, I'm good. Okay, so force majeure, first of all. This can be found in the articles on state responsibility, Article 23. It is very hard to prove. It's rarely successful and often used in acts of war, and it is also associated in private law with contract breach. Force majeure involves an occurrence of an irresistible force or an unforeseen event beyond the control of the state, making it materially impossible to perform an obligation. Force majeure cannot be used if the situation is due in part to the actions of the state, or the state assumed the risk of the situation occurring. So we might call this non-contribution, and this is an issue we've seen already today, and I'll come back to. It's not commonly used by states in investment arbitration, but there have been cases. In Autopista versus Venezuela, the tribunal ruled that force majeure can only be used when there is 1, an impossibility of performance, 2, unforeseeability, and 3, non-contribution by the state. And in that case, which dealt with a toll highway, and this was an ICSID decision in 2003 relating to civil unrest in that country, the tribunal ruled that the state failed to demonstrate impossibility, and the common law, English contract law anyway, the impossibility to perform a contract is very, very difficult to prove. So it's difficult for states to prove loss of control and unforeseeability in the context of COVID-19. And I would say that because of the continuing function of governments in most countries, we did not see a collapse of society. I don't know if you could describe COVID as an irresistible force. The fact that we have these vaccines that we're all taking, which reduce death rates, suggests that it wasn't entirely irresistible. And of course, there was also, on the foreseeability issue, previous pandemics. SARS in 2002, MERS in about 2012. And you might also add that states arguably contributed to the worsening of the pandemic by not reacting faster. So on to distress. This can be found in the Articles on State Responsibility, Article 24. Distress is available where the state is required to take action to prevent loss of life where there is no other reasonable way. And we always know as lawyers, whenever we hear the word reasonable, this imputes quite a bit of flexibility to the parties involved. Now, also under distress, the state must show that there is a special relationship between it and the persons whose lives are in danger. And as we saw with force majeure, distress also requires that the state did not contribute to the event and that the measures were proportionate. So just to be clear, distress is narrow in scope. It doesn't extend to more general cases of emergencies where necessity, which I'll mention in a second, is probably more appropriate. Now, in the context of COVID-19, I would suggest that the special relationship was likely met because of states' general responsibility for their citizens' lives. And I would say that's especially the case in countries where there's public health care systems. You might say that the special relationship is conferred simply by the fact that the government had the authority to instigate lockdowns. However, on the other hand, the special relationship is maybe questionable because in most countries, these measures, the lockdowns, for example, were implemented for the entire population, not just those who were vulnerable to COVID-19. So I think the special relationship component of this doctrine would have fit better with a shielding strategy, which was discussed at least in the United Kingdom about locking down, sheltering people above a certain age. Okay. On to necessity. So this is Article 25 of the Articles on State Responsibility. This is a more general defense aimed at dealing with general emergencies, and commentators that have looked at COVID-19, and there's a bit of literature out there already, suggest that this is probably the strongest claim. Necessity is available when the measure is the only way for the state to safeguard an essential interest against a grave and imminent peril. The state's act must not seriously impair the essential interests of another state or the international community, and the familiar requirement now, the state cannot have contributed to the situation. So it shares that element with distress and force majeure. So states, notably Argentina, have successfully used necessity as a defense in many investment claims. Sometimes, as I say, it's worked, sometimes it hasn't. It worked in continental casualty. And in that case, the tribunal ruled that there's a significant margin of appreciation for states in making these determinations. It also worked in LG and E. Sometimes it doesn't work, as in Enron. And in Enron, the tribunal ruled that Argentina contributed to the crisis. Now, with respect to public health type measures, which are the ones relevant to COVID, these are likely to be viewed as an essential interest, and we can distill that from some of the Argentina cases, including in Preglio, which dealt with the supply of water and sewage, which were seen as being vital to essential interests. So I think that starts to look a little bit like public health. But the only way will be difficult to prove, as in Enron, because some of the measures that many states took in response to COVID-19 were arguably excessive. For example, lockdowns and travel bans. And I'm going to come to that at the end and maybe make a somewhat controversial point. States may have contributed to the situation also by failing to act faster, which we've said before. Likely this will be assessed by reference to the conduct of other states. The CMS tribunal indicated that other states in comparable circumstances would be relevant. And also, with respect to contribution, did the state contribute to the state? The CMS tribunal looked at whether it was a sufficiently substantial contribution or a merely incidental or peripheral one. And that's going to depend heavily on the facts in each country. Lastly, on necessity, some of the measures that were implemented in response to COVID impaired other states' interests. So, for example, the vaccine and the PPE export bans, which you may recall in some of the darkest moments of the pandemic, were in many ways offensive to other countries' interests. Okay, on to police powers. The police powers doctrine may be part of customary international law or a general principle of law, but this is debatable, and I can recommend my colleague Catherine's excellent article on that issue, which I was reading in preparation for this presentation. Some ICSID cases have rejected this theory, turning to the Souffle Effect doctrine instead. So police powers protects the state's right to regulate over such important matters as public health, order, or morality. And the state, when making this claim, must establish a balance between the deprivation that results and the aim that is sought. The Azurix versus Argentina tribunal discussed this and said that intent must be demonstrated, not merely stated. So measures taken under police powers will not be subject to claims of expropriation or give rise to compensation by investors. Now, with respect to public health, we know that protecting public health has been viewed as an aspect of police powers by the Philip Morris versus Uruguay tribunal. This was the cigarette plain packaging case, or one of the famous cases. There, they rejected a finding of indirect expropriation, in part due to the fact that smoking declined pursuant to the regulation. Then we interestingly have Bischoff's case, which is a 1903 case against Venezuela, which was actually about a pandemic. This was the smallpox pandemic. And this involved the expropriation of a carriage, which was a passenger carriage for people. And in that case, the tribunal held that there was no liability for police powers measures because it was dealing with this smallpox pandemic. And that's the closest analogy that I'm aware of. But again, with police powers, reasonableness and proportionality must be shown. And once again, this could be problematic since many of the measures taken to combat COVID-19 may be viewed as excessive. So just to conclude, there are three plausible customary international law defenses available to states against investment claims related to COVID-19 response measures: force majeure, distress, and necessity. There's also the possibility that a defense of police powers could be used to justify public health related measures. I would suggest, and I think most of the commentators that have started to look at this issue, that necessity is probably the best bet. It's the most commonly invoked of these defenses in investment arbitration generally, and it has general application to emergencies such as a serious widespread public health crisis. The main problem seemed to be with necessity. And I would say you could really say this about the other defenses as well. First of all, the non-contribution issue. Did the state contribute to the disastrous state of affairs? And secondly, proportionality, reasonableness. Did they go too far? But it seems to me that these must be mutually exclusive. If a state contributed to the worsening of the pandemic because it didn't do enough, and I can tell you in the United Kingdom where I live, this was the widespread view that the government did not do enough. Certainly that's the narrative that the media pushed. Then logically, it could not have acted excessively. It didn't do enough, so how could it have done too much? So the question then really is, did any state, did any country get the balance right? I can't resist showing you this graph, and this is so controversial. Good old Sweden. Sweden, which adopted a very different approach to many countries in terms of not having the strict lockdowns. Not that Sweden did nothing, but it didn't have the strict lockdowns. And you may remember a year or so ago that Sweden was horribly vilified in the media, whether it's the Financial Times or the New York Times or the BBC. And now look where we're at. This graph on the graph on the left is of May 2021. The graph on the right is only from a few weeks ago. Sweden's 7-day rolling average of new deaths per 100,000 people is way lower than the EU average. And this is all these European Union countries that had these massively intrusive lockdowns that we know damage many people's lives, backlog with healthcare, psychological problems, depression, domestic violence, all these things. And yet it looks like Sweden really didn't fare much worse. So the question is, and I think you could add Florida into this mix and a couple of the other US states, were the lockdowns really necessary? Or did they just transfer deaths that would have occurred in 1 month to a later month? And I think it's these factual issues that scientists hopefully will unpick, and I don't have the expertise to evaluate, will probably play a role in deciding whether or not these types of defenses will work for COVID. Thank you very much.
Thank you very much, David. That was very, very clear. And thank you also for spotting and disseminating the Bischoff case, which is certainly a good trove. We have an extraordinary discussant who's extremely knowledgeable, as David just singled out, on these very topics. And without further ado, Catherine, we all look forward to hearing your stimulating remarks in this discussion. The floor is yours.
Thank you very much, Ashla. Thank you very much to the organizers for inviting me. It's a pleasure to be back in a conference in person and to actually see people in the audience. I have the same problem that Gisio had, that the presentations are truly excellent. I can only add my own comments, rather than I don't know, give a constructive criticism, because I truly enjoyed all three presentations. I will just share some thoughts that are triggered by the three presentations. I will start with some general thoughts that have to do with the importance of balance and proportionality, something that came up in all three presentations. And balance is, of course, essential. And the question I have is, where does balance come from? So what is the legal basis for balance? And what is balance? Balance is so subjective. And please don't get me wrong, I think balance is very important and it has to be relied upon in decisions. Also, balance is linked to proportionality. And so what is proportionality? Is proportionality general principle, for example? And I think there is a lot of unexplored potential in this context. For example, when we're looking at an exception, or when we're looking at the police powers doctrine, I think we are thinking in an all or nothing approach. You know, is the exception applicable? If the exception is applicable, then there is no treaty violation. But how about if we considered
I'm not saying necessarily that the wording of current treaties allows us to do so, but in terms of, let's say, treaty drafting at least, how about we think about introducing proportionality in treaties, or also with respect to compensation, so that the truth is not absolute. It's either yes, a treaty violation, and so yes, full compensation, or maybe there's a mitigated approach that we can have, where we can take into account factors such as conduct, the investor's conduct or state conduct. And then I'm going to move on to a different issue, and that is the well, we have three scenarios. When a tribunal is interpreting an investment treaty and is considering whether the conduct of the state can be excused. We can have treaty exceptions. We can have a language on regulatory interests without having exceptions. So we can have a mention in the preamble, or we can have a language in the treaty text. So CETA, for instance, has language to the effect that the state has the right to regulate. And what does that mean? So when the states reaffirm their right to regulate. And we can have treaties that have no relevant language, especially older treaties, and that have no exceptions. So when a tribunal is deciding a dispute, its decisions are going to be affected by whether one of these three, does the treaty have an exception? Does the treaty not have an exception, but still have some language on regulatory interests, such as the protection of the environment, or does the treaty have no exceptions at all? And then we have tribunal interpretations. When we look at the case law, we see that we have, even when the tribunals show deference to the state, or they say they show deference to the state, they can show deference and find that there is no violation, or they can show deference and still find that there is a violation. And of course, in every case, one has to look ad hoc at the facts of the case, because it is very difficult to give a general opinion about whether the tribunal has to follow one or another approach. One has to look at the facts of the particular case and, of course, the wording of the treaty. Now, when it comes to exceptions, so I will discuss exceptions, and then I will turn to Customary International. So when one considers exceptions, rather, I'm going to look at two different kinds of exceptions, which I think are the most important ones. And these are security exceptions. And security exceptions are, of course, very important because they relate to the core of the state. And general exceptions modeled on Article 20 of the GATT. And these exceptions are increasingly popular in new treaties, even though at the beginning, when Canada introduced them, there was a lot of resistance. And actually this, even though in WTO law, these exceptions existed, but in investment law, they sort of created this big debate, and they were criticized very much. But now investment treaties increasingly have them, and we have some first cases that have actually interpreted these exceptions. So the first cases, well, let's consider the security exceptions. So they, and in the context of the pandemic, I mean, as I don't remember who said it, I think maybe David, that this could be the pandemic situation, essential interest, essential security interest. I have a doubt now whether it could be an essential security interest, but if I don't know if economic security in the context of the Argentine crisis cases was considered to fall within the scope of the exception, of an essential security interest exception. I think the crisis, the health crisis could also fall in that context. When we look at the case law tends to be disappointing. The majority of the case law is made up by the Argentine cases that were initiated as a result of Argentina's crisis in 2001. And when we look at these disputes, at least the ones that have been resolved in arbitration rather than that have been settled, we see that tribunals, with the exception of the LG&E tribunal, in fact, did not apply the exception. They applied the customary international law defense of necessity, or at least they tried to, they considered whether the necessity defense was applicable. And we have some recent, I think if someone is interested, I can find the cases of the case. We have at least one recent case in which, or a later case, not related to the Argentine crisis, where a tribunal considered the essential security interest exception. It found that it did not apply. And I would just say that in general, when we look at the cases we have, we see that the essential security interests exception in investment law is not generally upheld. However, in terms of the technique of interpretation, it seems that the more recent case law, the very rare cases or case, I can't remember if it's one or a couple of cases, they have improved, and they have been influenced by the criticism in the annulment, some of the annulment cases, CMS versus Argentina annulment, and possibly, I don't know, Sembra and Enron. So I have some doubts about how security exceptions are going to be interpreted. Even though I think that there is an improvement, how likely are they to be upheld, even though I think that at least in this respect, interpretation has improved. Now, if one turns to general exceptions clauses, there we could have protection of public health, so measures taken for the protection of public health that would fall within such an exception. The following thoughts come to mind. First, we have very few treaties that actually have general exceptions. So these treaties are generally either Canadian treaties or they're very new treaties. Some of them have not yet been ratified. So in the future, we will have them because it seems like this kind of provision is gaining in popularity. But what happens now? We have some cases, some very recent cases, where tribunals have actually interpreted general exceptions clauses. And there, when we look at the interpretations, in fact, they're very disappointing. So I have two particular cases in mind. There are other, but I picked the worst for me cases, the worst interpretations of a general exceptions clause. And these cases are the Eco Oro versus Colombia and the Bear Creek versus Peru. So the Eco Oro versus Colombia was brought on the basis of the Canada-Colombia FTA, Canadian treaty. It had an exception on a general exceptions clause. So the dispute arose out of measures that prohibited mining in an environmental conservation area. There were measures that were taken for the protection, or allegedly, at least for the protection of the environment. And so the tribunal said environmental protection and investment protection. The state has to guarantee both environmental protection and investment protection. One does not exclude the other. And then the tribunal said that the general exception merely ensures, so that the tribunal looked at the general exception and it said, well, the treaty has an exception, but what the exception does is that it simply ensures that the state is not prohibited from taking the measures that are provided for in the exception. And I'm wondering, under what circumstances would a state be prohibited from taking any kind of measures it wanted within its domestic legal system? So, I mean, my question is, what was the meaning of the exception? So the tribunal essentially stated that the fact that the treaty had an exception meant that the state's measures were lawful. But even though they were lawful, this did not remove the duty to compensate. And I mean, one of my big disagreements with this decision is this question of compensation. what is the point of an exception if, despite upholding the exception, the state still has the duty to compensate? This is something that was said by the CMS Annulment Committee. It said something like, when it was considering Article 11 of the Argentina-US BIT, that if the exception applies, then no standards have been violated. And if no standards have been violated, there is no need to compensate. So in the ECOR case, the tribunal, well, it did not take into account the intent of the parties, even though it said that it did. One of the parties was, of course, Colombia, and Colombia argued that if the exception applied, there would be no need to compensate. But even Canada had submitted a non-disputing, sorry, I don't have the phrase. Canada had submitted an amicus curiae brief, and there it said that the exception applied, and if the general exception applies, then there is no violation of the treaty and there is no state liability. Payment of compensation would therefore not be required. So the tribunal ignored not only what Colombia said, but Colombia was the respondent in a way, but also what Canada said in that case. And then finally, the tribunal assumed that its analysis was supported by the ALSI articles on state responsibility, and especially Article 27, which deals with the consequences of invoking a circumstance precluding wrongfulness, and not the consequence of invoking a treaty exception. And also the tribunal considered that its findings were supported by Article 36 of the ALSI articles on state responsibility, which concerns compensation, concerns reparation in case of a wrongful act. Neither of the two were relevant to the case. Second case, Bear Creek versus Peru. Again, it was a mining case. It concerned the revocation of a mining license. Again, based on a Canadian treaty, the Canada-Peru FTA. The tribunal there looked at the general exceptions and said, because the treaty includes general exceptions, it means that, this is the lex specialis, so no other exceptions under international law are acceptable. I think this was a very quick finding and very general. Does the fact that a treaty has exceptions or general exceptions immediately mean that this is the lex specialis and no other defenses are admitted under customary international law? So I think this is a very questionable and very, very rapid, very quick finding of the tribunal. And for the same reason, the tribunal considered that the police powers doctrine would be inapplicable. So the tribunal would not consider the police powers doctrine because the treaty included a general exceptions clause. And like the ECOR tribunal, the Bear Creek tribunal considered that even if the general exceptions applied, compensation would still be due. So all this to say that I have some doubts about the interpretation, how tribunals have so far interpreted exceptions clauses. Okay, I'll stop here with that, and then I'll move on to customary international law. So let's assume now that the treaty has no exceptions, and so that the tribunal looks at customary international law. We have now I'm going to be overlapping a bit with things that David has said, but I'm going to focus on the necessity defense, and if I have time, discuss a little the police powers doctrine. So again, we have the interpretations of the necessity defense from the Argentine crisis disputes, but the Argentine crisis disputes, they not necessarily all of them, but the ones that have been mostly cited are ones that included a treaty exception. And so even though we have these interpretations of customary international law, these were really obiter because the applicable clause there was an exception, Article 11 of the US-Argentina BIT. There were two issues that make the defense very difficult to be invoked, at least as it has been interpreted in this case law. And one of them is the only way requirement, that one tribunal, the Sempra tribunal, considered the only way requirement, that the measures that the state adopts must be the only way that it can deal with the essential, can protect the essential interest. And the Central Tribunal said, there are, discussing economic crisis, it said, economic crisis in general, there are always other means available. Well, if there are always other means available, when did that tribunal imagine that this clause would be applicable? You know, what is the FAO deal of this interpretation? And of course, the other issue was the contribution to the crisis. That again was, I mean, these two requirements were also considered very often in cases when the treaty included an essential security interest exception. You know, the LGNE Tribunal as well, and the Continental Casualty Tribunal, the El Paso Tribunal looked at these. Sorry, I don't remember about the El Paso Tribunal. I think there was an applicable exception, but at least in LGNE and in Continental Casualty, where the tribunals considered that there was a case of necessity, that the respondent had not contributed to the situation to the crisis. In fact, again, these were obiter because they were being discussed in different contexts. And then for a few minutes, the 1.5 minutes that I have left, I'll talk about the police powers doctrine. Again, here we have two scenarios. One scenario is the applicable treaty includes a mitigated form of the police powers doctrine, such as in an annex. Discussing how a tribunal is going to make the distinction between a direct expropriation and a regulatory measure. And then we have the other scenario where the police powers doctrine is not present in the treaty text. And so in that case, the tribunal has to decide first if it considers it to be applicable, for example, because it is part of customary international law, as the Saluca Tribunal said, and as the Philip Morris versus Uruguay Tribunal said. And then if it applies, if it finds that it is customary international law and it is applicable in general, it will have to consider whether it is applicable in practice. And there the case law is again split. We have tribunals that accept it, and then we have tribunals that say that yes, they recognize the police powers doctrine, but then they find that the state measures were not a legitimate exercise of the state's police powers. These were just some general thoughts on the likelihood, on how tribunals address exceptions and defenses in customary law. Thank you.
Thank you very much, Catherine. I'm sure the organizers will be very happy of their own choice to ask you as a discussant, because you did a very great job, as good as that of the panelists. And you pointed the fingers on a couple of very rough spots concerning sad chapters in the history of investment case law when it comes to the application of the customary exception of state necessity, which prompts me to take back what I said to Julia. After all, what is the sense of scholarly exercise? What is these kinds of conferences all about, if not to develop some kind of methodology that sheds some wisdom and light for arbitrators to try and be consistent and reasonable? Clearly, the case you mentioned, Bear Creek versus Peru, was quite disconcerting, if only because if there is a clause which seems to have a similar scope of application as a customary piece of law, you would assume that the methodology there is to apply properly Article 31(3)(c) of the Vienna Convention and interpret the treaty rule, possibly in combination with a piece of customary law. One comment about your comment, and I mean, you opened in militating very much in favor of of a balanced and proportionate interpretation and application of rules which are basically made up of the principle of balancing expectations, the investor's due diligence together with the state's due diligence in order to look at the legitimacy of expectations and at the legitimacy of state measures. And all these considered, when we came down on the issue of balancing a piece of adjudication which finds justified restrictive measures, and the arbitrators found that despite the circumstance precluding the wrongfulness, therefore the measures complained of were found to be lawful, compensation was awarded. And you rightly refer to Article 27 of Ariswa that Julia knows that I have very much at heart, for its degree of incompleteness, because the International Law Commission didn't come down to any normative clarification of what they intended to say that assessment of circumstance precluding wrongfulness to apply is without prejudice to compensation. So clearly compensation that is envisaged in 27 is anything which falls short of full compensation arising out of as a consequence of wrongfulness. And thereas I see there might be on specific circumstances a possibility to find a balanced formula which on the one hand accounts for the legitimacy of the regulatory measures for public purposes, call them as you wish, police powers or whatever, but then some degree of balancing on legitimate expectations on the part of an investor who must have contributed to the development of economic development of the country and the rest of it as a matter of balance. So I'll stop there. That was my tiny point. And again, Julia, I take back a lot of what I said about perfection being the enemy of the good. We have to pursue perfection in order to be good. So the floor is open. I mean, the discussion was so rich that I'm sure that there will be only the embarrassment of the choice. Marco?
So thank you very much. Extremely interesting. This is a huge spoiler of my presentation tomorrow, but I cannot resist. There is a fil rouge with reasonableness. If I'm not mistaken, Sebastian mentioned the need for an objective element in the assessment of due diligence. And of course, reasonableness is, of course, important when it comes to necessity and when it comes to the police powers doctrine. And then, of course, reasonableness is extremely relevant to the FET standard. So there is an issue with reasonableness. So my question is, would that make a difference in your view if one could describe the behavior of the state as being in line with a document, and I use this word on purpose, or an act by a relevant international organization, which could be the WHO, but could be in principle the Security Council as well. So, and would that make a difference if such act could be described as binding or not? So in the assessment of reasonableness, a recommendation, an act, a document from a relevant international organization, would it make it easier, different, and what does it make sense to describe it as binding or not in your view? Thank you very much.
Can I try to jump in there? I'd like to slightly change the question to provide an answer, because I thought you were going to stop when you said a document such as an act, and then you said internationally. But let's take out the international element and stick with the document, the act. It's a piece of legislation or a report issued by the government. Once again, in the United Kingdom, in about 2016, the government wrote and issued, using scientists, a document about dealing with pandemics. It's not many years old. And you can see right in it, it says, under no circumstances will we ever do a lockdown because they don't work. And epidemiologists or whatever all supported this and said, no, never do a lockdown. What happens 4 years later? The government's under all kinds of pressure from the media, from other countries. Oh, we have to do a lockdown. But its own analysis, its own document said that they would never do it. So to me, that would be classic lack of reasonableness. But I took out the international element from the second part of your question.
Thank you. And substance for legitimate expectations on stability. Do you want to answer, Sebastian?
I have a short comment on the subject, namely, for the purposes of full protection and security, to have a document stating how the state should act in case, for example, of a pandemic would help in order for arbitrators to take into consideration what is the standard of conduct expected from the state. So it could be used regardless of whether it is binding or not, and preferably if it is international, to show what is expected from the state. So it might add some elements to the analysis of the tribunal. It will possibly not be conclusive because the tribunal might come to a different conclusion than this document of what is appropriate for the state in a specific circumstance, but it might help guide the decision. This is similar, for example, to, in my presentation, I briefly mentioned that tribunals might take into consideration, for example, if the state violated its own domestic law when adopting measures that are being analyzed through this prism of full protection and security. The logic is the same. So if there is a statement, a norm or a document establishing how the state should act, failing to comply with that document, inconsistency might indicate that the state has not fulfilled the standard of diligence required under the investment treaty. And the other way around, it also works, the argument also works. So if the state has followed every step in this document, it might be a strong indicator that it also fulfilled this minimum standard of diligence required under the investment treaty.
Thank you, Sebastian. I think these considerations link very much up with what Julia has been addressing. Do you want to comment, Julia, on this?
Yes, thank you. Well, I can just say, first of all, I didn't really touch upon reasonableness, but it's quite relevant, of course, for the assessment of the legitimate expectations, and often can be considered also made a parallel with the proportionality. And sometimes the steps are quite similar in this respect. So, and to regard to the question, I think such a document can definitely be used in the justification of the legitimacy of the state objective, and depending on the circumstance, of course, of the fact of the case, be considered and taken into account by the tribunal, and perhaps even thinking a bit further if such document is also binding, or perhaps if it's type of, has a higher legal status in this respect. There are cases which I mentioned in my presentation, such as Cintura or Philip Morris, where the international treaties in this respect. So it's a little bit different, but still it's regarding the binding element, such as in Cintura, the Aarhus Convention, and Philip Morris, the World Health Organization Convention, have been taken into account by the tribunal in considering the legitimacy of expectations.
Thank you very much, Julia. The next question comes from Professor Andrea Gattini.
Thank you, Attila. I appreciated very much the presentations and also the comments by Catherine. And I have only a little point on what Catherine said in relation to the presentation, especially of Dr. Collins. So, well, I found it very sophisticated your distinctions between treaty exceptions, customary exceptions, special exceptions, general exceptions. But I think we could not shorten, but make a little bit easier all these distinctions by starting from what the ad hoc annulment committee said in the CMS case very clearly, that the tribunal was wrong in applying general international customary law on state of necessity in face of Article 11 of the investment treaty between the US and Argentina, but still it was not a manifest excess of power. It was, well, they were wrong, but it was not that bad. I mean, it was not that obvious failure. And so I think the distinction, and it was President Guillaume saying that, El Arabi, Crawford, that means really the most prestigious bench which one could imagine. And so I think wouldn't be a way to do a little bit, at least to try to figure out what to do in case that either there is in the treaty a clear sample or a clear list of exception, or there is not. In the first case, then there is no space for going back to a customary international law. In the second case, no list, not a clear one. I don't see any problem in drawing back to general international law exceptions. So I think that would be the way to about what you said about Article 27 of international. I agree with Attila that, well, it's saving clause, Article 27, but that doesn't be in a saving clause, does not mean that there couldn't be space for imagine, not compensation in a strict sense, but a sort of indemnification. And that was possibly the intention of the ILC members at the time, because they dealt with it before going to compensation. And if you read the interventions by the members, so it was more the idea of not necessarily ex gratia payment, because of course states are always free to do that, but a sort of indemnity, indemnification, not compensation in a strict sense. So it's a matter of balancing and a matter of shaping. So a last point on the public policy, I have very much doubts that you can consider it, and that is a point which was raised also by Dr. Collins, so with the dubitative forms, and we don't know if it could be considered a general principle of law and customary international law. I think not at all. It could be a treaty exception if it is clear stated that the state has essential interests, national interests, whatever. But this public policy thing is a typical international private law exceptions or international private law tool, which has nothing to do with the public international law. Article 32 of the International Law Commission Articles on State Responsibility says very clearly that a state may never take some rules, domestic rules, as a justification for its wrongdoing. So thank you.
Thank you, Andrea. Maybe at some point, exactly, Catherine may want to reply to you, and then Dr. Sondra Faccio will put her question. Catherine.
Should I ask the question now?
Do you want to answer now? Maybe there is a question, another question.
Okay, let's take the second question.
Sondra, you.
Okay, thank you. My question relates to the police powers doctrine as well as to proportionality in the quantum phase that was mentioned at the beginning by Catherine. I'm not persuaded police powers doctrine will be an effective means of protection to avoid responsibility by states in case of measures adopted during the pandemic, when the measure actually is really expropriatory. We have a recent case of an award of 2021 involving Ukraine and Olympic entertainment concerning public health reason based. Ukraine adopted some gambling ban law based on public policy, public health reasons. The tribunal found out that actually there was public policy at the basis of the measure adopted by Ukraine, stated also that the measure was bona fide, but at the end concluded that there was an indirect expropriation because of the effects of the measure produced by the measure upon the foreign investors located in Ukraine. And so there was a public reason, but the expropriatory effects of the measure prevailed in the assessment of the tribunal, and that confirmed the trend of cases concerning indirect expropriation. And that turns to my question, which is a little bit what I also suggested in my studies. Why don't we consider the public reasons of the states in the quantum phase by applying proportionality? So I want to know your opinion on that, because you mentioned at the beginning that's an important element to take into consideration overall. Thank you.
Thank you, Sondra. That was a good attitude to let Sondra put a question, because that is also addressed to you, and perhaps also David may want to chip in at some point.
Thank you. I don't remember exactly what I said about Article 27. So I think I criticized the Ecoro Tribunal for considering that Article 27 was compatible with its interpretation, that it supported its interpretation of the exception. I did not question whether under Customary International Law, if, for example, the necessity defense applies, whether, I didn't say that if the necessity defense applies, then there should be no compensation. So I was discussing, and maybe I said something, maybe I didn't express myself well. And this gave rise to a misunderstanding. So yeah, I have no doubt that if the circumstance precluding wrongfulness applies, the question of compensation is open. Concerning the CMS annulment, yes, I think this is a very interesting approach. When we consider the apparently Crawford said in relation to the CMS case, we almost annulled it. And I would say that one of the reasons, in my opinion, why the reform of investor-state dispute settlement is considering the option of appeal in the ongoing negotiations in Onstall Working Group 3 is also the CMS case. I think the Argentine cases had a huge impact, and the fact that the CMS annulment committee said the award contains errors of law, but we can't annul it, I think was a big problem. And then I would say that there's the Enron and the Sempra cases that annulled the decision, and I'm not happy with either of them with their reasoning. So I'm not happy with the CMS case because it did not annul. But then the Enron and Sempra tribunals, one of them said that if we have an egregious misapplication of the applicable law, then this is manifest excess of powers. And the other tribunal said, the other annulment committee said the tribunal in fact applied what the expert said rather than the law. So they annulled it for that. It applied the wrong law because it didn't apply the law, but it applied to something very weird like that. And I would have simply said, I mean, I wasn't involved in the cases, so there may be details that I don't know. My gut reaction, knowing the few facts that I know, would be that the tribunal did not apply the applicable law. The applicable law was the exception. The tribunal applied applied Customary International Law and the security exception. But that's just a matter of interpretation. Of course, it's perfectly acceptable to consider that it's not an important mistake. And just a quick comment on proportionality. Yes, I think this is very interesting. I'm not entirely sure how. I haven't really worked on compensation, so I'm not entirely sure how one would go about in light of the treaty wording, but often treaties are vague and they don't have specific rules about how to accord compensation. So I would say, in principle, not having thought this through, it would be perfectly acceptable for a tribunal to do a proportionality analysis and award compensation. And just the final sentence on apportionment of costs, I think this may be similar. So when a tribunal is apportioning costs, especially if it decides on, if it takes into account which of the parties has won, if one party has won a bid, and then I think there is a de facto balancing in such a case. So I think, yes, that sounds like in principle a great idea.
Yeah. Sebastian asked for the floor. You have the floor, and then maybe David, if you wish.
So I just had a short comment on the issue of security exceptions. So I believe that after these Argentinian cases, and there is like a new one, the Mobile versus Argentina, which was published a little bit later, and the annulment was in 2019. There was like this state of necessity approach in which Article 11 of the Argentina US BIT was interpreted following the criteria of Article 25 RCWA. But there is like, after annulment committees, including the Mobile Committee in 2019, rejected this approach, even if they decided not to annul the awards, but they rejected as a matter of law the approach of this necessity approach. There have been new cases in which it is assumed that the security exceptions contain like an autonomous exception, and they analyze the exception on its own terms. Examples would be the Divas case, Divas versus India, or Deutsche Telekom versus India. In both cases, we see that the standard of review is very deferent to the state and is based on the specific language of the treaty exception, avoiding to incorporate this language or these criteria from general international law. I would like to add that maybe in the future, the discussion will shift a little bit. And it will shift because in the newest treaty practice of some states, there has been an attempt to turn security exceptions in investment treaties into non-justiciable exceptions. That is the case of the Indian model BIT, which excludes jurisdiction over security issues. And there is a very interesting development also in Asia, that is in the Comprehensive Economic Partnership Agreement between Indonesia and Korea, where there is a public health exception, which is excluded or excludes jurisdiction of the tribunal over health issues. Interestingly, this agreement was negotiated or signed during the pandemic. It's an agreement of December 2020. So I think that maybe the discussion will turn into this debate on whether eventually a security exception would turn into a jurisdictional issue under these new treaties. The discussion was closed in this Russia trafficking transit case in the WTO, where it was clearly stated that the security exception of Article 21 GATT is subject to the jurisdiction of panels, and then it is a justiciable exception. But the question might reopen as the states reacted against this general consensus that the exceptions are justiciable and tried to include them within jurisdictional clauses. And just a final footnote on security exceptions, I believe that there is a third element or a third corpus of case law that is usually not taken into account when analyzing security exceptions, and is the ICJ. The United States incorporated security exceptions in many friendship, commerce and navigation treaties in the 50s in the Eisenhower administration mostly. And those clauses have been analyzed, interpreted by the ICJ in many cases, including the Nicaragua case, the oil platforms case, and in two more recent cases concerning, there is this case concerning Iranian assets and another one in which the ICJ has actually considered the language of the security exception. So that might be another element of analysis which might be useful if one wants to draw comparisons between WTO law, ICJ case law and investment arbitrary practice.
Thank you very much. Those were very good points. Thank you very much for making them. David, would you like to react?
Well, I didn't really have much else to say. I wanted to just pick up on Sandra's previous question with respect to using quantum of compensation with respect to public policy exceptions. Without any reference to specific case law, I've often felt that as a forum, as an adjudicatory system, investor-state dispute settlement is particularly well suited to precisely that methodology. I think attenuating compensation based on the degree of public policy utility is precisely one of the ways that balance could be achieved. And if you contrast that with, let's say, the WTO, for example, it's a non-monetary compensation regime. It's either all or nothing. Either the measure is valid, it satisfies Article 20, in which case the measure can remain, or it does not, and the measure must be removed. Whereas as soon as you've got monetary compensation, you have a continuum through which you can sort of proportion responsibility, much as you might do with contributory negligence in a contract claim. And the point on costs, I think, is also well made, that costs could also be used for that. So it wasn't much new, just wanted to add my views on that.
Well, thank you very much. I think that we can wind up, and I'm very pleased, and I thank you very much, and thank you organizers for having invited me to take part in this very stimulating discussion. Thank you. Have a nice rest of the day.